All rise. The Court of Impeachment of the Texas Senate is now in session.
Welcome back. We are resuming our coverage. A bit of a longer lunch break than we intended. The Senate was set to come back at 1 p.m. for the trial to resume. It's now 1:38, and you can see Lieutenant Governor Dan Patrick taking his seat as they were trying to answer this question as to whether or not they were going to allow into evidence pictures and a sworn affidavit from State Senator Angela Paxton. These are photos of
them
of things, catalog pictures of sinks,
things that they items
and things that the Paxtons were considering putting in their home as they were renovating their kitchen. And the concern from the prosecution was that a sworn affidavit from Angela Paxton is, in their eyes, testimony from Angela Paxton, and there are rules that lay out how you would have had to
submit that testimony,
or request witness testimony from someone who is a part of the court and a juror. And so that was the question before us, really at about noon today. Dan Patrick wanted to wait and take the lunch break until 12:30, but we took a lunch break at 12 as this came up so that they could look. We're seeing a lot of
big group up there now.
From the prosecution, by the way, that's prosecutors shaking their heads unhappy. So we will see. Certainly, will be interesting to see what this ruling is. This could really be a key ruling in all of this.
It really could. I mean, if the defense believes they have information that shows that Angela Paxton was heavily involved in the purchasing and selection of items for their home, you can see why they would push to have it in. So it's just going to be interesting to see how it all shakes out.
And this kitchen renovation, we want to note, while it was sort of assumed that the kitchen renovation was what the insurance money was going to be used to pay for, we heard Paxton's body man, Drew Wicker, testify that the insurance claim on the Paxton homes for the renovation was actually for the master bedroom, and it is the master bedroom that sustained water damage due to a storm here in Austin, and that's what the insurance was paying for. But at the same time that was happening and that renovation was happening, the Paxtons decided to also renovate their kitchen.
And again, the allegation is that Nate Paul was paying for that renovation to their kitchen. It is an underpinning for one of the articles of impeachment, but even more broadly, it's also the foundation of some of the public knowledge about this case. And what I mean by that is it establishes, according to House impeachment managers and prosecutors, it establishes the quid pro quo, the benefit that Ken Paxton allegedly received.
And so Lieutenant Governor Dan Patrick saying that there's some sort of resolution between the defense and the prosecution on this, but that they're going to bring it back up tomorrow. That they're going to sort of drop it for now, and then they'll deal with it tomorrow. I find it interesting that they'll deal with it tomorrow when we know there's a time period.
Not much time,
a 24-hour time period to lay out before a witness or testimony can be submitted. You have to give the other side 24 hours. So certainly interesting to see what the implications of that could be if we're going to wait until tomorrow to work that out. And let's talk a little bit about the witness coming back into the Senate chamber right now.
His name is Drew Wicker. He was Ken Paxton's executive aide. We're talking about the person who traveled with him, kept his schedule, and perhaps more than anybody in this whole story would have had the most intimate interaction with Ken Paxton.
The prosecution has already questioned him reluctantly, as we would say, as he does not want to testify, and now Busby is cross-examining, so let's listen.
Would you mind putting in front of our senators Article 10, please? Drew, help me here a little bit. Article 10 alleges constitutional bribery. Do you see that?
Yes, sir, I do.
It says in the second paragraph, specifically, Paxton benefited from Nate Paul providing renovations to Paxton's home. Did I read that right?
Yes, sir, you did.
You understand that's the allegation being made, right?
Yes, sir.
Now, you had told us about a conversation you heard at the Paxton's Terrytown home, right?
Yes, sir.
It was you, it was General Paxton, and it was a gentleman named Kevin Wood in the kitchen, correct?
That is correct.
Now, of course, you've told us all that you never saw Nate Paul at General Paxton's home, true?
That is correct.
And you knew that the Paxton's home had water damage, right?
Correct.
And you knew Kevin Wood was the contractor, right?
That is correct.
And you knew that the Paxtons had decided to do some additional renovations at the same time they were fixing the water damage, right?
Yes, sir.
And you say you were in the kitchen with General Paxton and Kevin Wood, and they were talking about redoing the countertops, right?
That is correct.
And the mention was that Angela wanted granite countertops, right?
That General Paxton and her had both decided they would like granite countertops, correct?
And you said that at some point the cost of that was mentioned to be $20,000.
Yes, sir.
Okay. And you can't tell us here whether the Paxtons actually got these $20,000 countertops, can you?
No, sir.
Now, one way we could figure that out is for all of us to go to the Paxtons' home right now, couldn't we?
Yes, sir.
I mean, Your Honor, we could right now, if the court would allow it, get on a bus and drive over to Terrytown and look at the Paxton's countertops. Could we do that, Your Honor?
Objection relevance, Your Honor. He can bring in photographs if he chooses to that were taken at a current time period.
I'm going to overrule. You simply ask a question of something I could do.
Yes, sir. And we may make a motion in that regard, but maybe we can fix it in this way, Your Honor. We had previously looked at an exhibit put into evidence by the House Board of Managers. Let's look at House Board of Managers 703. And Eric, if you would, turn to the fourth page of this exhibit that's in evidence. And we can see here, can we not, that Kevin Wood has a email that's sent on July 4th, 2020. Do you see that?
Yes, sir.
And he attaches some pictures of the home at that point in time, right?
I can't see that, but I do see that there are attachments.
Okay, now let's turn over, Eric, if we could, to the page bait stamped 29672 within that exhibit. And pull that up so everybody can see. And try to bring that picture up so we all can see it, Eric. All right, now we can see what that kitchen looked like as of July of 2020, can't we?
Yes, sir.
I want you to look very carefully at it. Can you see the stove?
Yes, sir.
Can you see the countertops?
It's a little bit grainy, but yes.
And that's how the house looked when you were in that kitchen with General Paxton and with Kevin Wood, isn't that right?
It was mostly covered up by renovations, but yes.
Now, so this is, we'll call this the before, okay?
Yes, sir.
This was the before, the suggestion that we're going to make those countertops granite, right?
Yes.
And we're going to redo the cabinetry, right? That's another thing you mentioned.
Yes, sir.
All right, now let's go back, if we could, to the picture that's in evidence and marked as AG 371. And bring that up. Eric has the most stressful job in this trial. No pressure, Eric. Okay. Here we have a picture of that same kitchen. Is that true?
It would appear so, yes.
And you see the same countertops that you saw in the previous picture, don't you?
It would appear so, yes.
And you see the same cabinets as in the previous picture, right?
Again, it would appear so.
So the question is,
I'm going to object, Your Honor, to relevance. I don't believe this is in the packet that we're referencing. Mr. Busby could cite me if I'm incorrect.
I've already said this is in evidence at AG 371.
Overruled.
The question is, when was AG 371 taken, right?
Yes, sir.
Because if this picture was taken on August 22nd of 2023, then anybody with any common sense would know that nothing was done to the cabinets or the countertops, right?
That would be correct.
May I approach the witness, Your Honor?
Yes, you may.
Before we testify about it, just confirm with me that what you've been handed, which is now...
Objection, Your Honor, to publishing a document that's not in evidence that he has not attributed for the record.
I have not published anything at this point, Your Honor.
The picture is on the screen, Mr.
That's the
Busby.
picture AG 371. This is something different.
Overruled.
Now, take a look at what I've handed you, AG 1051, and would you confirm with me that the picture you're holding in your hands is the same picture that we see on the screen, which is AG 371?
It appears so, yes.
And do you see the exhibit you're holding in your hand has, in fact, the date and where the picture was taken?
It does.
Your Honor, we offer AG 151.
Have you shown it to the defense?
May I see a copy and the date that was referenced?
It's coming to both of us. We'd like to have one. Okay.
Give a
We'll
copy
give it
to the
them
other
first.
side,
Give it to them
please.
first. And you can give us a copy. Sir, you can give us a copy. Oh, that's the only one you have?
You have another copy?
Mr. President, I don't want to stave off his direct, but cross, but I think that I can clear something up if I could take Mr. Wicker on a brief for Dyer. I think he's been misled as to the date and time of the photograph he had originally identified.
Again, Your Honor, I'm asking this witness if he has now the date the picture was taken on a cell phone, the exact same picture that's already in evidence. It's not very hard. We're going to get to the truth here.
Overruled.
Tell us, sir, the date of the picture you have in your hand.
It states that it was Tuesday, August 22nd, 2023 at 4:50 p.m.
And where was the picture taken?
It says Austin, Terrytown.
Your Honor, we offer AG 1051.
Do you object?
I do, Your Honor. Objection hearsay. He hasn't established a proper predicate to make it relevant to this trial. It doesn't have an address, and Mr. Wicker cannot say that he fairly and accurately depicts something that he's actually seen.
Overruled.
Now, Eric, please publish for the ladies and gentlemen of this distinguished jury the picture of the Terrytown Paxton home that was taken in August of this year. Do you see there, sir, that the cabinets have never changed?
It would appear so, yes.
Do you see there, sir, that the
President?
countertops have never changed?
Mr. President, I'm sorry. I must insist. He's provided metadata, but without any source for it. I am not trying to impugn his character, but this is a court of law, and he has to establish the predicate for the information that's contained below. He has not done that, and he intends to rely upon it. It is hearsay.
It's in evidence already, Your Honor. You've ruled on it. It's in evidence.
Your Honor, with all respect to Mr. Busby, he's misleading you. The photograph is in evidence. The information contained beneath it is not. That's what he's asking you to do now.
Again, we can look back with the court reporter. I offered 1051. The court allowed it.
In that case, Mr. President, it is fully within your discretion to correct an error. I am not conceding that it is admitted, but if it were, in light of the fact that he cannot establish that anything beneath that photograph is true and he intends to dance upon it, I would ask that the court help correct that issue.
That picture, Your Honor, as you can tell, is the same picture that's in evidence. The only addition to it is now we know exactly when the picture was taken and where it was taken.
Which establishes the exact issue, Your Honor. There is no one here who can establish whether or not this picture was in fact taken August 22nd, 2023, and any 12-year-old can create that graphic on a computer.
Your Honor, this lawyer is suggesting that me, an officer of this court, has somehow doctored a picture when I've offered to go over to the home right now and look at the kitchen and it'll look exactly like that. Why would somebody who has an obligation as a prosecutor to find the truth try to prevent the truth from coming out? This is in evidence. The picture's in evidence already. The court's allowed now the picture in evidence that shows when it was taken. I would allow.
I am not trying to impugn anyone's character. I am acting as a prosecutor and a rule follower, and I expect to do that here so no misimpressions are left with the court.
This is allowed in evidence.
Thank you, Your Honor.
Overruled.
Now, you care about the truth, don't you, Drew?
Yes, sir.
And you want the truth to come out, don't you?
I believe it has to.
Yes, it's important, isn't it?
Yes, sir.
And now we see that the picture of the Paxton home, we can see that there were no work done on the countertops, can't we?
Yes, we can.
We can see that there was no work done in the cabinetry, can't we?
Yes, sir.
Pretty clear, isn't it?
From those images, yes.
Accusing someone of bribery for accepting granite countertops and new cabinetry is a very serious allegation, isn't it?
I would agree.
And you understand that Mr. Paxton, General Paxton, has no obligation to prove anything, right? He's being accused.
Yes, sir.
He didn't have to prove anything, does he?
Yes, sir.
But we've proven that the countertops were not altered in any way, haven't we?
The countertops appear to have not been altered.
The
That's
cabinets have not been altered in any way, have they?
It would appear that way, yes, sir.
And in fact, we've created a comparison picture. It's exhibit 1052, AG 1052. May I approach? Can we agree, Drew, that 1052 that you're holding in your hands is a picture, the one on the left is the one we just looked at, right?
Yes, sir.
And the one on the right is the one we looked at from Kevin Wood, right?
That is correct.
And they're side by side on this exhibit, true?
That is correct.
And we know the one on the right was taken in July of 2020, right?
Yes, sir.
And we know the one on the left was taken years later, August 2023, don't we?
Yes, sir.
We offer 1052.
Do you have a copy of that? Would you please provide a copy?
To clarify, I see AG 371 and I see House Board of Managers 73 on 1052. Which one of these two photos is supposed to be 1051?
I'm not answering her questions, Your Honor. I've offered this exhibit.
Then I object to relevance.
This is a comparison, as I've laid out with the witness. He's established the relevance of this picture. It compares the one taken in years back in 2020 with the one taken last month. We'd offer it.
Overruled.
Will it be accepted, Your Honor?
What is the number again?
1052.
1052 is admitted into evidence.
Thank you, Your Honor. So can we agree, Drew, that your concerns now have been put to bed, at least with regard to the countertops and the cabinetry?
With regards to those two items, yes, sir.
I mean, now you're satisfied, right?
Yes, sir.
Okay. Now, I want to show you some other documents and evidence. I mean, it shouldn't be that a friend, a family member has to prove their innocence, should it?
In a court of law, my understanding is that they're supposed to provide evidence to answer the charges. The answer to your question is no, you're innocent until proven guilty.
Yeah. AG Exhibit 332. Thank you, Eric. This is an invoice. Can you tell us all the date of the invoice?
The date of the invoice is September 1st, 2020.
And the invoice is from whom?
Cupertino Builders.
And I just want you to keep that date in your mind, September 1, 2020. Can you do that for me, Drew?
Yes, sir.
All right, Eric, go to AG Exhibit 410. Can you see the date there on this USAA claims correspondence?
September 16th of 2020.
So here we are 15 days after that invoice that we saw previously.
Yes, sir.
And turn the page, Eric. And we can see as of that time, the claim being made with regard or with USAA is being administered.
Yes.
Okay. AG 428. Drew, this is a document that's in evidence from the state of Delaware. Do you see that?
I do.
And do you see it's a document related to Cupertino Builders?
I do.
And can we agree that that's the same entity that we saw in the September 1, 2020 invoice?
Yes, sir.
And would you look at the very bottom line that gives us the date that that company was incorporated in the state of Delaware?
It appears that the filing was April 16th of 2020.
So what we know is in April of 2020, Cupertino Builders was incorporated in the state of Delaware.
Yes, sir.
And we know that months later, it issued an invoice to the Paxtons for work on their home.
That's correct.
Go back to the invoice, please, Eric. Go back to AG 332, Eric. I just want to look at this invoice that was issued September 1, 2020, okay? Turn to the second page, Eric. Do you see the total amount invoiced to the Paxtons for the renovations of their home?
$121,000, $817.
You have a pen with you?
No, sir, I do not.
Drew, would you do me the favor of writing down the amount of that invoice on your Post-it note there? $121,617.
Yes, sir.
And we know, of course, that Cupertino Builders was a Delaware corporation as of the time this invoice was issued.
That is what it says.
Let's look now at AG Exhibit 48. And turn, Eric, if you would, to the bait stamp EBT 184. These are some text messages between General Paxton and a guy we might hear from in this case named Chip Loper, all right? And could you pull that text up, Eric? We saw that invoice was due on September 30th, 2020, right?
That is correct.
And now we have a text from General Paxton to his blind trust, or his trustee of his trust, instructing him to make a payment, don't we?
That is what the text message says, yes.
And confirm with me, if you would, that the amount that Chip Loper, the trustee, is being instructed to pay is exactly the amount that's on your Post-it note that you just wrote.
I can confirm.
Say it again.
I confirm that.
Exact, right?
Yes, sir.
Eric, bring up AG Exhibit 47. So what we've seen so far, Drew, is we've seen an invoice that's due on September 30th, right?
Yes, sir.
We've seen a text from Mr. Paxton to his trustee instructing him to pay, right?
Yes, sir.
And we know those amounts are the same, true?
Yes.
And now what we have in front of us is a bank statement from Prosperity Bank, right?
That is what it says.
And would you please confirm with me, go to page, we're looking at AG 47, go to page 116, EBT 116. And would you confirm that the day after Mr. Paxton, General Paxton, sent the text to his trustee that a wire was made from Mr. Paxton's account of $121,617?
I can.
And is that the same number that you wrote on your Post-it note?
Yes.
And let's go to AG 333. Do you see here that this is another record from a bank, BBVA?
I do not see BBVA. Oh, yes, I do. Okay.
Okay.
At the very top.
Business Choice Checking account?
Yes, sir.
And can you confirm that that account received a wire in the exact same amount as you wrote on your Post-it note?
Yes.
And it matches to the letter, to the penny, the amount of the invoice
Yes.
and the amount of the wire out of the Paxton's account?
I don't see where this says that this is the Paxton's account.
We saw the previous Paxton's account. What we've seen is the invoice, the wire out, and the wire in, haven't we?
Yes.
Okay. When you raised your concern, because, I mean, that's what you raised it first with some of the folks in the office. Is that how it went?
I sought advice from a trusted individual who brought me into the office first, yes.
Is that Brickman?
No, sir, that was Mark Rylander.
Okay, so you went to Rylander and said, look, I heard something that sounds a little weird. What do I do?
Yes.
Because you didn't know what to do about it.
No, sir.
And what he told you to do, hey, just raise it with General Paxton, right?
His advice was that if I was comfortable raising it with General Paxton, that I do so, and that I also informed Blake Brickman as my direct report.
Okay. And he told you that your understanding was just wrong, didn't he?
That is what General Paxton said, yes.
He also told you he appreciated you bringing that to his attention, right?
That is correct.
And you accepted that, didn't you?
Yes.
And it seemed logical, didn't it?
I still had some questions, but yes, I did take it at face value.
And he never told you not to tell anybody, did he?
No, sir.
I mean, he never said, hey, keep it on the down low, Drew, did he?
No, sir.
He told you specifically, Drew, I'm paying for these renovations, but I appreciate you sharing that with me, but that is not what this is, right?
Yes, sir.
And you took his word for it, didn't you?
I took his word for it.
Now, you don't have any personal knowledge about any relationship General Paxton may or may not have had with anyone named Laura Olson, do you?
I've only witnessed them together the one time.
So you don't have any personal knowledge about their relationship other than you saw a woman come out of an elevator, right?
I saw Laura Olson come out of an elevator, yes.
Okay. Now, these trusted people you mentioned in the office, you were talking to them often, weren't you?
On a daily basis.
Y'all were friends.
Yes.
Did you know they took General Paxton's name off the letterhead?
I don't know what that's
Objection, Your
referring
Honor.
to.
Facts not in evidence
I'm
and
asking if
proven
he
to be
knows.
false in the course of this trial.
Sustained.
Did you ever discuss with them taking General Paxton's name off his own letterhead?
No.
Objection, Your Honor. Question calls for hearsay, and it's facts not in evidence.
Sustained.
Now, just so we're clear, you are not accusing or providing any evidence that General Paxton did anything wrong in this case, are you?
The only evidence that I bring to the table is what I overheard and what I've reported. That is it.
Pass the witness, Your Honor.
Watch your foot. I don't want to hit your foot there. That's all right. Your witness.
Thank you. Mr. Wicker, you sometimes ran personal errands for General Paxton, is that right?
That is correct.
When you did that, were you advised which service you were using, the campaign fund money or work money? Did you have to attribute where money was spent or your time was spent?
I wasn't compensated for most of those services, so no, I was not.
Okay, thank you. The second, because Mr. Busby asked you extensive questions, you told us that the damage was in the bedroom, correct?
Yes.
And did you see actual renovations anywhere in the home outside of the bedroom?
Yes.
Is it fair to say if you knew people were looking into your countertops and your cabinets, you might choose at that point not to get them upgraded?
Objection,
Yes.
speculation, Your Honor.
Sustained.
Okay. Do you know in the course of working with the adjuster and looking at Steam Clean and those groups that work for the insurance side, or let me do this differently. Do you know that payments were made by insurance?
I do not know that firsthand, no.
But we've all taken as a given, I think, through the course of talking to Mr. Busby, that more further renovations were done, correct?
Yes, and that's what the document said.
Okay. I want to clarify something else, and I'm sorry to put you on the spot. When Mr. Busby was showing you pictures of the kitchen, do you have an independent memory now in regards to what what the countertops looked like, or are you taking his word for it?
To the best of my recollection, those were the countertops.
I do not want to lead, so I'm going to ask you a question only because of a prior conversation. The answer doesn't really matter, but I want to clarify. Didn't you say redo the granite countertops when we first spoke, meaning what was being changed may or may not be granite again?
That was a mistake on my part, and as I mentioned to both you and Mr. Busby, I had to amend that statement to be more consistent with other statements made to law enforcement.
I see. So you've already had a conversation specific about this with Mr. Busby?
I did.
Okay. Have you and I had this particular conversation?
To the best of my recollection, yes.
Okay. And so when you made that correction for yourself, it's not because you were lying the first time, right?
No.
Okay. What is the most relevant part of that conversation with Kevin Wood? The renovations, which we know took place, which people only know about because of you, or the state of the cabinets and countertops?
Objection, Your Honor. Leading, number one, and number two, I don't think it's appropriate to ask the witness what's most relevant. That's the court's job.
I think I've made the point. It's okay. I'll move on.
Sustained.
Thank you. How many times did you hear the phrase, "I'll have to check with Nate"?
3 times
Over the course of one day or multiple days?
in the course of one conversation.
Thank you, sir. Do you have any question then that on 3 different occasions, the response to a question directed at Kevin Wood about financial impact of renovations was, "I'll have to check with Nate"?
That is correct.
Since you've already spoken to Mr. Busby, let me ask you a few questions about that. How did your conversation go? Did you call him or did he call you?
Whenever we were in preparing for this trial, every effort was made whenever the House team reached out to offer the same thing for the defense. And it was in response to that, in preparation for this testimony here today, that my counsel and I both reached out to Mr. Busby's team to have a conversation prior to me taking the stand.
That's an honorable and fair thing to do. Had you made prior efforts to speak to Mr. Busby or Paxton's team?
My legal counsel had, yes.
On your behalf?
Yes.
And at any point until the last week, did they take you up on that?
They did not.
He asked you a lot of questions about whether or not you overheard an agreement between Nate Paul and Ken Paxton. Do you recall that?
Yes.
Do most people who are working together stand on top of a mountain, hands on their hips, and say, "I'll do this for you if you'll give me X"?
Objection, Your Honor. That's an improper question. Leading and
Sustained.
I mean, come on.
Do you understand that law enforcement and this investigative body can use circumstantial evidence to
Objection,
determine
Your
whether or
Honor.
not there's a conspiracy?
I'm sorry to interrupt. Objection, improper question. Speculation.
Sustained.
Yes, Your Honor. Let me do this differently then. Do you have any memory of when the Paxtons moved back into their home?
This would have been probably August, September timeframe, if I had to guess.
Okay. May I approach the witness, Your Honor? For the record, I'm showing him what's marked as 698 and not in evidence as a document to refresh his recollection. Mr. Wicker, do you recognize that?
I do. If you can just give me 1 second to read.
Yes, sir.
Can I get a copy of that, Your Honor?
And we'd like to have a copy.
I mean, in candor, there are multiple copies over there, but I don't have them. May I take his and pass it around?
Yes. Give it to the defense first. We'll stop the clock for a moment. Are you ready?
I am.
You can resume the clock.
Since we do have a copy for everyone, I'm going to change course, actually. This is a text message that's included in 698, which is a set of documents provided with a business records affidavit, which have been provided to defense, and they've had notice of it for over 14 days, at which point I would move to admit 698.
I have no objection to this, Your Honor.
The court will admit Exhibit 698 into evidence.
And would you publish? Thank you, Stacy. Who is this a conversation between?
This states to be a conversation between myself, Mark Rylander, and Jeff Mateer.
What is the date?
It appears to be July 19th of 2020.
Okay. And do you see any reference to when the Paxtons might be moving back into their home?
It appears that it was around that time frame. So judging by the context here, he had been storing clothes at the AG's office, and we moved those back around that time frame.
Okay. So fair to say then the Paxtons' home was at least renovated enough for them to return to it in the middle of July?
Yes.
And would it surprise you to know that nowhere in those Cupertino records is there an invoice or estimate at any time during June or July?
I did not see that.
Leading, Your Honor. I'm going to have to object to leading.
Sustained.
Next, let me ask you. Let's turn to item 683, which is already in evidence. And Mr. Wicker, I'm sorry to take advantage of you since you're on the stand, but I need to recap a couple of things Busby went through. Tell me, if you would, the date on this document.
September 30th of 2020.
This document has been admitted as what we refer to as the cease and desist letter. So notice to Brandon Kamek to stop working. Are you aware of that time frame in the office?
I am.
And do you know that Brandon Kamek reaches out to Ken Paxton to let him know their problems?
I learned this later, yes.
Okay. But does this email corroborate what you heard?
It does.
Objection, Your Honor. I'm sorry. He just said he heard it later. That's hearsay. Now she wants him to corroborate hearsay with something else improper.
Sustained.
Okay, let's look at the document itself. September 30th, cease and desist letter to Brandon Kamek. Let's look at item 130. Do you see the date on this letter?
September 30th, 2020.
Is that 130? Oh, yes, ma'am, please. Sorry, Stacy. Thank you. Do you see September 30th referenced on this document as well?
I do.
And in the records provided by Esther Blind Trust, this is the first conversation about payment to Cupertino. Would that surprise you?
I was not aware of Esther Blind Trust, so I'll take your word for it.
So, but September 30th, Brandon Kamek is notified that there's a problem. Ken Paxton finds out, and the first thing he does is tell the Esther Blind Trust to send $121,000 to someone else.
Okay.
I'm going to turn your attention to item 223. I think this is also not in evidence, so do not yet. It is in? I got thumbs up from the side. In that case, will you pull up item 223? I'm going to have you scroll down, Stacy, to the return. Do you recall General Paxton being out of town at the end of September, early October, as the whistleblowers are coming forward and law enforcement is being notified that they're concerned he's accepting bribes and misusing the office? These questions are no different than the way he phrases them.
If I could, without being interrupted. Your Honor, this is outside the scope. I just want to flag that for the court. I'm going to let her do this because I want to talk about a few of these things that are outside as well.
It is outside the scope, but he's not objecting, so he will be able to do the same.
Yes, Your Honor. If it would have been helpful, though, I took extensive notes. Mr. Busby opened up all of these doors for me. Yes, sir. Thank you.
You're both out of scope, okay? You're both free.
On October 1st, do you know where General Paxton was in regards to the office? Did he come in?
No, ma'am.
And I'm going to have Stacy scroll down a little. Are these texts between you and Jeff Mateer?
Can you scroll up? Yes.
And what is it that you understood on October 1st was happening with the general?
I really didn't have an understanding at that time.
Did you think anything about the fact that he wasn't there or didn't want you to let people know what he was doing?
Objection, Your Honor. Leading, and he's already said he doesn't know.
Sustained.
I'm going to read from a document because it is in evidence. Says he has a lot to do out of the office and that I'm to tell anyone that asks that I don't know where he is. Is he telling you to lie?
I don't know that he's asking me to lie, just to state that I don't know where he is.
Stacy, if you would, please turn to Exhibit 131. Pause for a moment. In the upper left-hand corner, do you see that this account is affiliated with the Esther Blind Trust?
I do.
The same organization that was being told to make payment the day before by text, at least according to the documents and evidence before you.
Yes.
Do you see, scroll down for me, do you see that same $121,000 payment, $617, being made as it was requested by Ken Paxton?
I do.
And do you see who the recipient is?
Cupertino Builders, LLC.
Miss Stacy, if you'll pull up 703 for me, please. I'd like to see page 21. All right, Mr. Wicker, do you see who is supposed to be the count holder on these documents? It's under business choice checking, specifically choice.
Cupertino Builders, LLC.
And do you see the first line in the transaction sheet?
It shows an incoming wire in the amount of $121,000, 617.
Consistent with Cupertino being paid for remodeling or doing work at Ken Paxton's house, if that's what he has alleged, correct?
Yes, ma'am.
Let's turn to page 3. These are the same records that include Kevin Wood, the contractor who you personally met, who helped facilitate whatever upgrades Ken Paxton might want, a person whose email address suggests he is Nate at World Class, and an individual named Raj Kumar. Is that correct?
Yes, ma'am.
Stacy, may we see the face of the business record affidavit? Do you see before you that the business records we've been referencing and that are already admitted belong to Cupertino Builders?
Yes.
Would it surprise you to know that, as Mr. Busby pointed out, it's when they were in Delaware and before they opened a Texas affiliate? Would you have any reason to be surprised by that?
Objection leading, Your Honor.
Sustained.
Do you also see that the individual otherwise referred to as Raj Kumar is in here named, I'm gonna butcher it, frankly, on the second page? Narsima Raju Sigaraju.
I do see that.
It was a valiant effort. I saw your smile. Next, Stacy, may we see page 16? Is this the same invoice Mr. Busby showed you a moment ago?
It appears to be, yes.
The same invoice that he splashed in his press conference for representation of General Paxton?
Objection, Your Honor. Improper question. She's talking about the press conference? I mean, that's not proper.
I'm going to sustain, rephrase.
Stacy, if you would for me, please turn to page 22. Now, Mr. Wicker, in all of the records before you, if there had been payments or estimates or supplies or timelines or communication in regard to payment in any way, in regards to Ken Paxton and Cupertino, don't you think Mr. Busby would have pointed it out?
Objection, Your Honor. Leading.
Sustained.
Then the very last thing I would like to ask you is this. In regards to the document, the invoice we had just looked at, this document is the metadata that was provided by Cupertino. It is already admitted into evidence. Please tell me what date that invoice was created.
October 1st, 2020 at 7:50 p.m. Central Standard Time.
After the whistleblowers, after he knows that you're aware of the renovations, after a cease and desist, after directing payment, only after all of those things does he get the first piece of documentation that would in any way credit that it was valid.
Objection leading.
Sustained.
I guess I'll end where the defense began. There are no coincidences in Austin. But the next piece, I think...
Objection to the sidebar.
We've had a lot of sidebars in this
A little bit of sidebar.
trial. I'll give you a sidebar. They've had a few.
One sidebar.
Overruled. You're even now on sidebars, okay?
The very last piece, I wish I could have ended there, but I need to get in the Uber records we discussed yesterday. The court had already said that they could be admitted after extensive arguments between both sides. I just failed to offer on the record for their admission.
Go ahead.
House moves to admit item. 700.
700 will be,
Take care of this.
we've already settled that, right? 700 yesterday. Okay, 700 will be admitted into evidence.
Your Honor, can we be heard on that? I think we have, I didn't know this would not be the right witness for this, but can we be heard on
Yes.
those records?
We spoke extensively and the court ruled yesterday.
Your Honor, we saw, apologize.
I'm going to object to using the time, and may we approach?
Okay, we'll stop the clock for a moment. Approach.
Let's recap some of what we just heard.
My
because
goodness.
it seemed as though Busby made
was dismantling.
Completely dismantled and made these points that no, the payment had happened, that the Paxtons received insurance money and had paid this exact
that there was
amount.
an invoice in early September, that they were merely acting, that Ken Paxton was acting on this invoice by calling his trustee and asking him to send this payment for about $121,000.
The number is so exact, $121,617, and then lo and behold, we get the metadata from that invoice
presented by Epley on redirect
that shows that invoice was created in the evening after Ken Paxton had been learned
about the whistleblowers going to the FBI.
That they told him that. And what else is interesting is that the invoice was created for the exact amount of money that the insurance company had given them for the repairs to the master bedroom. And so that really is interesting that, again, it's funny because Busby was sort of proving this point that it was the exact amount of money that the insurance gave them.
Right.
But that would also speak to why he was charged that exact amount of money for this invoice.
Epley did not call this a cover-up, but she barely stopped short of using that word.
And I think barely stopped short because they've been joking about how many sidebars each person gets. But this is certainly where it seems like
she just on redirect turned this whole case around. Yeah.
Or certainly turned this article around.
Yes, exactly.
Because we were at the point, we're talking about Article 10, which alleges that Nate Paul paid for a kitchen renovation for the Paxtons. Obviously in exchange for all the things that you've been hearing us talk about, Nate Paul has been, how the prosecution and the witnesses have said Nate Paul has benefited from having access to the AG's office. And Busby really came in his cross-examination and just tore it to shreds.
Right.
From look at this. The kitchen isn't renovated. Look at the countertops and the cabinets; they're the same. That doesn't mean that the rest of the kitchen is not renovated.
That's right.
But to say that didn't happen, and look at this, he got the insurance money approved in September, and he on September 30th sent a text message to his trust to say, send this payment. And then when Epley comes in and say, okay, well, he sent that text message to send that exact amount of money, but he didn't have an invoice until the 1st.
Until the 1st, yes.
In the evening, that is,
it's important.
It's critical.
And she started that redirect by just repeating and asking Drew Wicker once more. To be clear, according to Drew Wicker's testimony, it was not one time in passing that he heard, we need to check with Nate.
Yeah, I'll have to check with Nate.
That Kevin Wood, the contractor, said, I'll have to check with Nate.
In terms of the things that they were being asked to do during the renovation.
In fact, he said it was 3 times. On 3 occasions,
during one conversation.
He heard
it 3 times. Interestingly enough, you have Wicker who, he heard this, he had this concern, and so he asked some of Paxton's top aides, frankly, for advice. How do I handle this? I heard this. What should I do? And they told him, you should ask Paxton about it. And he says he did. He says he did, in fact, go to Paxton, and he did ask him about it. And Paxton said, "It's not what you."
Right, you've got it wrong. You've got it wrong, man. Yeah.
No, thank you for coming to me with your concern, but that's not. You didn't hear that right. That's not how this is happening. So certainly.
And look, we're clearly not sitting on the Senate floor. It's hard to kind of tell what the vibe is down there. But I got to tell you, it seems like it's got a real serious tone right now, just judging by the looks on people's faces and what's happening here.
Well, and also because of, what we just heard. It seemed as though Tony Busby put Article 10 to bed.
Yes.
he, and then lo and behold, not so fast.
Epley resurrects it in a pretty profound, monumental way.
Monumental is a great way, I would say, Tony, to describe.
I mean, certainly, we want to be careful about the pejoratives,
Sure.
our word choices
Sure,
here, but objectively.
Objectively, because what she's alleging is huge, that
Right.
this invoice was not even created until that. Yes, sure, he sent a payment for an amount of money, but that the invoice requesting how much money wasn't even made until after he had sent the money.
And I also want to just point out, and I'm looking, there's been so much happening in this case, but I'm looking at an Associated Press article that was recently published. It's important also, just for the sake of this discussion here, that the money to Cupertino Builders, the manager of that company was an associate of Nate Paul, according to state corporation and court records. And so it's not as though this company, Cupertino, was just some construction company. There was a link to Nate Paul.
And that in and of it, that in and of itself, and is something
Noteworthy to say the least.
To say the least. As we are continuing to hear the prosecution sort of unravel this case, I'm seeing the attorneys return from the dais now to, back to their respective sides. And I'm trying to, before this, happened and they took this pause, Epley was trying to make one last point.
Yeah. Also, Ashley, I do want to go back in time a little bit too, because Epley referred to, what was her verb? When Tony Busby slung the receipt on the screen, or what was she used? Some verb talking about the one news conference that Tony Busby has had. Where
he slung the
slung
invoice,
it. That's what she said, that he slung the invoice.
This is the same invoice that he slung off, during his press conference.
Again, show to demonstrate that the Paxtons had in fact paid for the home renovation. And I can just tell you that the showing of that transfer instantly raised questions in the minds of many people because the timing was just so striking to people who had been following this case. Wait just a minute, you paid for this work the same day that your deputies went to the FBI and reported you? What's going on here?
And it was paid for months after it had already been completed.
Yes.
Wicker was testifying that at some point, they couldn't stay in the home, and Paxton was keeping his clothes in the AG's office. But at some point in late June, early July, they moved his clothing back into the Paxton home, and so that's June, July, and yet you wouldn't pay this invoice to a construction company for the work that they've done on your home until September.
I'm just reading from an Associated Press story here. It says last year a court-appointed overseer for some of Paul's companies wrote in a report that Cupertino Builders, that's the company, was used for fraudulent transfers from his business to a man who had been convicted of fraud in California in 2016, who was an official with Cupertino Builders.
That's not good, Tony.
It's not good.
Basically, what Tony just read to you is very not good, that this company had been caught up in creating fraudulent transfers, which you take that back knowledge, that obviously we have because we're able to look it up in real time. The senators, certainly not supposed to be doing that given the gag order and the rules.
And then this echoing what I said earlier, the timing of the payment and the identity of who was paid for renovations at the Paxton's home was not publicly known before Paxton's new legal team held a news conference in which they put financial documents on a projector screen while criticizing the impeachment.
Right. They sort of told us who was doing the work.
Yeah.
And so that
It's not a great moment
it's
for
not
Team Paxton.
good for Team Paxton. It certainly is not. Now, of course, we're going to have, Tony Busby's going to get the opportunity to come back up and ask a few more questions of Drew Wicker about this.
But it was.
But the data doesn't.
Yeah. Well,
supposedly.
I mean, look, this metadata has been very.
We've certainly heard a lot.
I've learned a lot about metadata
before.
in the past few days, but.
I mean, that is what is supposed to show you. The
when
backside
yes,
of
exactly.
information.
When it was created, when it was altered,
when it was sent. Right. If it was
altered, yes.
When it was altered, all of that's the same thing that the forensic examiners were looking for. They were looking into the metadata of the search warrants that were used to raid Nate Paul's properties to see if they had been altered.
But
as Paul claims.
But in that case, experts said that the metadata, what appeared to be metadata changes, were not in fact metadata changes, that the search warrant was encrypted by the federal government, and that's why it appeared as though there was this metadata
that they
alteration.
found no evidence of it being
tampering,
altered,
being tampered with.
On the spot.
Yes.
That's a great way to describe it. But this metadata, I mean, we haven't heard anyone.
Well, Tony Busby did not stand up and say, prove it. Who is your expert? Who analyzed this metadata?
Which is the opposite, frankly, of what we saw Epley do when she talked about the pictures of the Paxton's home. So interestingly, they showed Drew Wicker pictures of the Paxton kitchen from 2020. And then 2023, him saying that, the countertops again and the cabinets are the same. Let's listen back in because it's certainly going to be some interesting rulings
We'll come
here.
back to order. Where were we? Ms. Epley, were you up here? I think you were. So when we last left, and you can restart the clock, you were asking to admit 700.
Yes, Your Honor.
There was an objection. We've looked at the two documents. I had ruled that in yesterday. We see that they are similar, and so 700 is admitted into evidence.
Thank you, Mr. President. Pass the witness.
Eric, would you do me the service of putting on the screen what's in evidence, House Exhibit 571?
Objection, Your Honor. I don't believe this document has been admitted.
We offer 571 if it's not in evidence.
I'd ask that he take it off the screen, Your
Take
Honor.
it off the screen for now, Eric. We all know Eric,
We love Eric.
and everyone knows Stacy.
It's actually in evidence, I'm told.
We're checking. You don't have it? We'll check. Is this the House or AG's?
House Board of Managers Exhibit 571.
That is, Ms. Epley, it is in evidence according to our records.
Thank you, Your Honor.
Very good. Thank you.
All right.
Pull it on the screen, Eric, and make it big. And make sure you capture the time and date of this text. Get the date too, Eric. I'm going to need somebody to confirm the date. Penley 5. As we're getting this date, can you see there that there's a text sent from Jeff Mateer to General Paxton where he tells the general that yesterday each of the individuals on this text made a good faith report of violations of law?
I can.
Do you know what date that was done?
I do not.
Okay. If this text was sent on October 1st, because we know they went to the FBI on September 30th, that means they were sending this text the day after, correct?
Yes.
On October 1st, 2020. Make sense?
Yes.
So on October the 1st, 2020, Jeff Mateer, along with several other individuals, sent this text to General Paxton, right?
That is what it appears to be, yes.
Now let's look back now, if we could, Eric, at the date and time that the general instructed his trustee to wire the money to pay for his home renovations. You heard the suggestion, I'm sure, Drew. You heard they suggested he only did that because he knew that his people had went to the FBI?
Objection, compound. I don't understand the question.
Overruled.
Yes. You heard that suggestion, didn't you, Drew, that the general learned that a few of his subordinates went to the FBI and therefore he hurriedly sent a text to pay for his house repairs? You heard that?
That was the insinuation in the last line of questioning, yes.
That's what she was insinuating, wasn't it?
That is what I understood, yes.
But the truth is, if we look at AG Exhibit 48, and we go to EBT 184, could you just tell us all, so we'll be clear about how the timing actually was? What was the time and date of when the general instructed his trustee to pay for his home renovations?
September 30th.
And that's also the same date that the invoice was due, right?
That is what the invoice said was due, yes.
Okay, and can we agree that September 30th, 2020 is before October 1, 2020?
Yes, sir.
Now, when we talked previously, I failed to ask you something that's real important. First, did these folks, how many times did you interview with these folks over there to the right?
I've spoken with them 3 times in preparation for this.
Okay, and the only reason you spoke to me is because you felt it would be fair to let me have a chance to talk to you as well after you had talked to them.
Anytime they reached out, I reciprocated and extended the same offer.
Okay. Did they ever show you any of the documents I showed you today?
Not to my recollection, no.
They didn't show you the bank wire showing that General Paxton and Angela Paxton paid for their renovations?
Not to my recollection.
They didn't show you the text message to the trustee instructing the payment?
Not to my recollection.
They didn't show you the document showing that the wire was actually received by the contractor?
Not to my recollection.
You ever wonder why they didn't do that?
Objection, Your Honor. Question calls for speculation.
Sustained.
There was a suggestion that you delivered some kind of document to Nate Paul. Remember that suggestion?
Yes.
You said it was a manila envelope?
Yes.
You had told us that you picked up an envelope from Vassar that had a CD taped to it?
I don't recall that it was taped.
It was inside of it?
No, sir, it was on the exterior.
On the exterior of the envelope?
Yes.
You know for sure you didn't deliver that envelope to Nate Paul, don't you?
Not that envelope, no.
Okay, let's be clear. Whatever Vassar gave you that was checked out, you didn't check anything out, did you?
No, sir, there were signatures on the document, but I don't recall checking anything out.
Right. Vassar gave you something that you gave to the general, right?
That is correct.
And that particular document had a CD on the outside of the envelope.
That is correct.
And that certainly was not the envelope delivered to Nate Paul, was it?
Objection. Question calls for speculation and lack of foundation based on Drew Wicker's previous testimony.
Sustained.
Did the document or the envelope that you delivered to Nate Paul, did it have a CD on the exterior?
It did not have a CD on the exterior.
Okay. And just so we're clear, you never met Nate Paul in the dark of night in an alleyway and delivered anything, did you?
No, sir. It was in the afternoon.
In the light of day?
Yes.
It wasn't a secret at all, was it?
No, sir.
You did hear some conversations between Nate Paul and General Paxton, didn't you?
Yes.
Let's focus on what you heard. One of the things that was discussed was whether the raid by the federal agents.
Objection. Normally I wouldn't mind, but since I tried to elicit this exact testimony and don't want to waste the senator's time with a second redirect, I must object to hearsay.
She already asked this question, Your Honor. I'm just clarifying what she asked this young man.
I did ask it, and he objected despite me being absolutely certain it would come in. And at this point, he doesn't have the same exception because Ken Paxton is not his party opponent.
Sustain.
Sir, you know that the focus of the conversation was whether the raid was just. Isn't that true?
Objection. Question calls for hearsay.
Sustained.
You know that the discussion that they had was whether the FBI had followed the rules, right?
Objection. Question calls for hearsay.
Sustained.
You know that Mr. Paxton, General Paxton's discussion was whether the feds had violated the law. Isn't that right?
Objection. Question calls for hearsay.
Again, Your Honor, we've heard, he talked all about what Ken Paxton has said, and I'm entitled to explore that, exactly what was said.
He successfully shut down this entire line of questioning, whether he should have or shouldn't have, and he shouldn't be given the latitude now because he does not have an exception to hearsay.
Overruled.
You know that what your boss was saying was whether Nate Paul had been unfairly targeted, right?
In the discussions that I was privy to, Nate Paul did most of the talking.
Whether he had been unjustly targeted, right?
That was the concern that he expressed.
Because you know sometimes the legal system gets politicized, don't you?
Objection. Relevance.
He was asked this by the Board of Managers, Your Honor.
Overruled.
You know that sometimes the legal system gets politicized, don't you?
Yes, sir.
And Mr. Paxton, General Paxton's concern was whether there had been a miscarriage of justice. Isn't that right?
Objection. Question calls for speculation.
He said it in his own words, Your Honor.
He can't say that in his own words, Your Honor.
Sustained.
Now, you knew that General Paxton had some distrust of DPS, didn't you?
Objection. Relevance and hearsay.
Overruled.
You knew that, didn't you?
I did.
You never heard General Paxton say he was going to do anything for Nate Paul. Isn't that true?
He never stated that he would take any action directly on his behalf, no.
Now, there was some suggestion about something that you delivered in a manila envelope, right?
Yes, sir.
Was it like this one?
Yes, sir.
Just like this?
Very, very similar, if not the same.
You don't know what was inside of it?
No, sir, I did not look.
You have no evidence to offer about what was in the envelope?
No,
Objection.
again, I
Asked and
did not.
answered.
You do know, of course,
Overruled.
that it was a couple of pages at most, right?
What I stated was that I do not recall the thickness of the document.
Was it this thick?
Again, sir, I do not recall.
You can't say that it was anything near this thick, can you?
I can't
Objection,
say
Your
that.
Honor. Inconsistent with his prior testimony, he's mischaracterizing the evidence. Mr. Wicker used his fingers to show roughly, 2 centimeters to an inch in thickness, which is consistent with what is in Tony Busby's hands.
I appreciate all the speaking objections you ask us not to do, but I'd like to finish up so we can get on down the road.
Overruled. Go ahead.
Now, could it be, let me ask you, did you ever exchange texts with Nate Paul?
I don't recall any text exchanges, no.
May I approach the witness, Your Honor?
You may.
Would your text refresh your recollection?
If there are any, yes.
Now, you've got a chance to look at the document without testifying what's in the document. Does that refresh your recollection?
Yes.
Okay. You had told us that packet, the manila envelope you delivered was sometime in the summer, maybe even the fall, right?
No, sir. The testimony that I provided was summer.
Summer, June, perhaps, right?
Yes, sir. Earlier in the day, I stated that it was likely May or June.
And that text you had that you were exchanging with Nate Paul was in June of 2020. Isn't that true?
Yes.
And you exchanged text with Nate Paul before you delivered an envelope just like this one, didn't you?
Objection, Your Honor.
I'm asking the man a question. I'm entitled to an answer.
Overruled.
You exchanged texts with him before you delivered an envelope just like this one. Isn't that true?
Objection, Your Honor. It assumes facts, not evidence. Drew
I want
Wicker
some
has
time
been very
back with this
clear
foolishness.
about the timeline, and Mr. Busby.
Overruled.
Didn't you?
I don't recall whether or not this text message occurred before a delivery or after.
Can we agree that you were texting Nate Paul about Dick Weekly?
That is what the text messages show, yes.
Can we agree that you delivered to Nate Paul information about an event Dick Weekly was holding because Dick Weekly was trying to get Nate Paul to donate money to Texans for lawsuit reform?
No, sir.
You don't remember that?
No, sir, I do not.
Can we agree that that text that you're holding in your hand confirms that you were texting information about Dick Weekly to Nate Paul?
It does.
Your Honor, with that, I pass the witness.
The briefest of redirects, please, Mr. President.
Get one.
You're back up.
May I proceed?
You may.
Is the conversation you had with Dick Weekly, if it existed at all, something that would have to be delivered by hand to Nate Paul?
No.
What was it? What was the construct of the conversation?
The conversation that I had with Dick Weekly was with General Paxton on his Dick Weekly's back porch, in which we were engaging in a fundraising conversation. I do not recall Nate Paul having been mentioned, and if it was any information tied to TLR, I don't see why that couldn't have been sent via email, if that's the question.
So completely made up in regards to this, to your knowledge?
Objection leading, and also, Your Honor, I'm just curious, if we're going to keep questioning the witness, you're going to get extra turns like this?
You'll get one more cross and then we're
Okay.
done because this is the first time we've gone to 2 redirects and you'll have a chance to recross. But I thought the lateness of the trial would allow it. I think you smiled knowing I'm sustaining his objection.
I did. Thank you, Mr. President. Do you have any reason to think that this story Mr. Busby has told you has anything to do with that manila envelope?
Objection leading.
Do you?
Sustained. Try another way.
Thank you. Did you ever need to deliver an invitation from David Weekly to Nate Paul?
Not to my knowledge.
Pass.
I mean, yes, sir. The truth is you don't know what you delivered, do you?
That is correct.
Pass the witness, Your Honor.
Are both of you, can we dismiss the witness? Excuse the witness, rather?
I think must have missed, yes.
Subject to recall. Okay. You're excused, subject to recall. Thank you. Mr. Harden, who should we have the bailiff bring in?
I'm sorry?
Which witness are you calling?
Mr. Blake Brickman, please, Your Honor.
Bailiff will bring in Mr. Blake Brickman.
Mr. Busby,
Blake
Busby,
Brickman,
are these your
the witness who is now being called, was also among the whistleblowers. So, Ashley, correct me if I'm wrong, that will
Mr.
make
Harden, as we
7
move forward, we're gonna
whistleblowers who have
break
now
around
been called.
3:30 for a short break.
We had,
for planning purposes.
oh, taking a short
Actually,
break. Yeah.
we're going to pause there. And I say we're going to pause because
Just call for
they're
a short
talking
break.
about
right?
taking a short break until 3:30. And now at this point, we have to wonder if the prosecution is simply calling witnesses to bide their time until 3:53 p.m. when they are eligible to call Laura Olson, whom they want to call. She is the woman who was having an who Ken Paxton was having an extramarital affair with.
And the reason 3:53, in case you're late to this, is important is because the parties are required to give 24-hour notice to the other side, to the opposing side, so that...
And to the witness
And to the
themselves.
witness themselves, that's right. It's a dual purpose there, to ensure that the other side has time to prep. But we know that Laura Olson was in the Senate chamber earlier today. I didn't finish my thought. 3:53 is when her notice, or when the notice went out yesterday. So at 3:53 today, it will have been 24 hours. Okay, that person right there is Blake Brickman. Are we not taking a break? I'm sorry, I understood we were taking a break.
I understood that we were to take a break, but perhaps we're going to
Raise your right
question him
hand.
for 30 minutes.
I do solemnly swear or affirm that the
And take
evidence
a
I
break
give
And
upon
take a
this
break at
hearing by the
3:30.
Senate
Got
of
it.
Texas on impeachment charges against
which
Warren Kenneth
that
Paxton
we
Jr.
just both-
shall be the truth, the whole truth, nothing
Yeah.
but the truth, so help me God.
Blake Brickman,
please be seated.
also one of the
Speak
whistleblowers
close
who
to the mic
was a
and speak
party
up.
to the whistleblower lawsuit.
Mr. Harden? you're on
Let's
the clock.
listen to his testimony.
State your name, full name, please.
James Blake Brickman, but I go by Blake.
How are you presently employed?
I work here in Austin at a venture capital firm.
I'm going to move pretty fast with you here, but I don't want you...
You need to move closer to the mic.
Yeah,
Mr.
you need to come through. I'm going to move pretty fast here with you, but I don't want you to speak fast. I'm just explaining to you, they'll come kind of hot and heavy, okay? Would you give me an idea of where you grew up, your college, and your jobs before you got to the AG's office?
I grew up in Dallas, Texas. I went to Vanderbilt University, and I went to the University of Kentucky College of Law.
And when you finished, and during the time that you were going to school, did you go to law school at night school?
Yes, sir. I was the chief of staff for United States Senator Jim Bunning in Washington, D.C., and I went to night law school during that time.
And then did you work for another politician before you came back to Texas?
Yes, I was Governor Matt Bevin from Kentucky's chief of staff from 2015 to 2019.
My memory is that Governor Bevin was considered a pretty conservative governor, was he not?
He was probably the most conservative governor in the country.
Is that the history of your public employment?
It is.
All right.
Senator Jim Bunning was also known as the most conservative senator at the time. Rand Paul took his seat when he retired.
All right. Now, when you came back to Dallas, what year did you come back, and how did you end up at the AG's office?
I came back in the end of 2019. I interviewed for a position as Deputy Attorney General with Jeff Mateer and Attorney General Ken Paxton in December of 2019 when they personally recruited me to come back to Texas.
And did General Paxton himself interview you and ask you to come back and come?
He did. I met with General Paxton in early 2019 in Austin. And then after Christmas in 2019, he offered me the job when we had lunch at Campese's in Dallas together.
I have Attorney General Exhibit 170.
Can I move this closer?
I think it should be either right after or right before that, Stacy. I didn't have the page number. Thank you. Would you read that, please, out loud?
This is a message from General Ken Paxton to me. And it's
Dated what date?
January 11th, 2020.
Is this right before you started, or had you actually started?
This is 2 weeks before I started, so
Go ahead.
I got a text from both Tommy and Doug Deason, both singing your praises. I think highly of both those guys, so you keep good company. I'm looking forward to your coming to work with us. You're going to fit in great and be a tremendous asset to our team.
And that is that, with that kind of endorsement, is that the way you began working for for Attorney General Paxton?
It is. Tommy Hicks is who he's referring to, who at the time was the co-chairman of the RNC and a very close friend of Donald Trump Jr. Doug Deason is a conservative philanthropist in Dallas who is well known in the Republican Party.
All right. Now, when you began, what was your position?
I was in charge of policy and strategic initiatives, but because I had not waived into the Texas bar, my title initially was not Deputy Attorney General because I did not waive in until about June of 2020.
All right. When was the first time that you heard the name Nate Paul?
Sometime in either late March of 2020 or early April 2020.
And without going into what was said, did you have a conversation with the young man that was called the Body Man?
I had a conversation with Drew Wicker. Drew Wicker came to me.
And where was Drew Wicker's position in relation to you?
Drew Wicker reported directly to me.
All right. And was Mr. Wicker concerned?
He was very concerned.
And did he report to you his basis of his concern?
He did.
And what did you tell him?
Objection, hearsay.
That's fine. We'll just move right along. Did you give him some advice? Just yes or no?
Yes.
All right. And later, did he inform you that he had followed through on that advice?
Yes.
Objection, Your Honor, hearsay.
All right. Did you become aware ultimately of who it was that he was concerned about?
Attorney General Paxton was meeting privately with a man named Nate Paul without his security detail present and without the meetings being on his personal calendar, on his official calendar.
And was Drew concerned about him periodically getting rid of his security detail?
Your Honor, I'm sorry, I object. We heard from Drew Wicker. This is hearsay.
Sustained.
My only question was, did he relay his concerns about that matter without telling me what they were?
Yes.
All right. Now, I want to move now to September of 2020. Over a period of time, without going into detail, had you become familiar with and heard the Nate Paul in connection with other matters on several different or multiple occasions?
Yes, sir.
Objection, leading, and hearsay.
That's not leading. I've just asked whether he did. He could have said no, or he could have said yes.
Overruled.
Thank you. Now, by the time we hit September the 29th, what was your state of mind as to what your concerns were about Mr. Paul?
I was extremely concerned about Mr. Paxton's conduct. My office was about 5 feet away from Attorney General Ken Paxton's office. And what I saw over the course of those 3, 4, 5 months, the summer of 2020, I was very concerned that Mr. Paxton was breaking the law.
I want to go, if I may step away to get an exhibit, but first I want to ask you about your relationship up until the summer when you started having concerns with the Attorney General. Was there a particular occasion back in the spring in which the Attorney General sought to praise you?
Yes, sir. Attorney General Paxton and I had a very good relationship for the first few months I was in the office.
All right. Well, may I step over here, Your Honor? May I approach a bit, witness, Your Honor? Now, would you identify the exhibit I just showed you, which is obviously a book, and what exhibit number, just for identification purposes, is it?
It's Exhibit 705.
And what is the title of the book?
The book is called Scalia Speaks, about Antonin Scalia, Justice Scalia.
And where did you get that book?
Attorney General Ken Paxton gave this book to me in front of 40 or 50 of the most senior employees in the Office of Attorney General in May of 2020.
When did he give, in May, that's what I was going to ask you. Did he inscribe it?
He did.
Is the inscription in the first page?
It is.
What did he say?
Would you like me to read it?
Yes.
Blake, I am so grateful you joined our team at the Texas AG's office. You have been an amazing addition. I'm confident that you will continue to make a difference for our office and all of Texans. Blessings, Ken Paxton.
Thank you. How would you characterize whether that is an accurate description of the way he talks to and about you up through the month of May of 2020?
It was accurate.
All right. Was there a particular event that you'd been involved in on behalf of somebody that led him to be giving you that book and an award?
Yes, sir.
What was it?
This was early May of 2020. And if you remember, that was at the very beginning of the COVID pandemic. And there was a situation in the DFW Metroplex where I'm from, where there was a hairdresser named Shelley Luther who was put in Dallas County Jail because she violated a stay-at-home order so she could provide for her family.
How did that involve you?
I went to Attorney General Ken Paxton and said, "Sir, this is wrong that this is happening in this country."
And what was his reaction?
He said, "Well, what can we do about it?"
And you said?
I said, "You should speak out about this. This is wrong. Use your bully pulpit," and he did.
And as a result, what was his reaction to that?
He did several interviews. He was on Fox News talking about this. Tucker Carlson even praised him
And
in early May of 2020. So he was very happy, and this was my idea.
And of course, there were other public officials that then also spoke up around that same time, correct?
There were many others after the fact, yes.
All right. And so as a result, what was the Attorney General, of you having suggested that to him and it turning out well, how was his attitude toward you as you entered June of 2020?
It was great. That's why he gave me the book. He had never done this before, is what he told the entire staff. He had never made an award like this ever before.
All right, now let's go to September the 29th, September 30th of 2020. You said you had become concerned. You expressed some of those concerns. What was the focus and what was giving rise to it for you personally of September 29th and 30th of 2020?
I witnessed Attorney General Ken Paxton do brazen things on behalf of Nate Paul. He abused the entire office of the Attorney General of Texas to benefit Nate Paul. And it got worse and worse and worse as the year progressed.
Were you one of those who went to the FBI on September the 30th?
Yes, sir.
And are you also one of those that has been colloquially called a whistleblower?
Yes, sir.
Well, when you went to the FBI, did you go with other persons?
There were 7 of the most senior staffers at the Office of Attorney General. We went together.
Now, there seems to be some confusion in some parts of the world as to what evidence is. Did y'all take evidence with you?
We did.
And what did you take in the form of evidence to talk to the FBI?
Again, this was the 7 most senior people in the agency. We took firsthand personal knowledge of Ken Paxton's illegal, immoral, and unethical conduct to federal law enforcement officers.
You took yourselves?
Yes.
And would you describe the meeting as to what y'all did?
Sure. The meeting lasted several hours. I don't remember exactly how much, but we all went around the table and shared our concerns with Ken Paxton's conduct.
Is that evidence?
It is.
Did you give eyewitness accounts of what you observed?
Yes.
Would that be just like an eyewitness account of somebody seeing a robbery?
Yes.
All right. Sometimes the victims of robbery don't have any documents on them, do they?
Correct.
All right. But at the end of that time, had each of the 7 of you provided your evidence of what you believed was inappropriate and wrongful conduct by the Attorney General?
We did.
All right. And at that time, had you seen the grand jury subpoenas that were issued?
I had seen 1 or 2, but not all of them.
All right. And then, after that meeting, were you present when it was decided to send a letter to actually, who did y'all send letters to? Let me put it that way.
We sent a letter to Greg Simpson, who is the head of HR for OAG.
Now, it keeps being this, I thought it was dead, but not, I guess not. It keeps being this suggestion that somebody removed a letterhead from a letter that you sent. Is that true?
I don't even know what that is referring to.
All right. Did you see, was a letter sent without General Paxton's name on it?
I believe the letter we sent had the Attorney General's crest on it.
All right. What was the practice there as far as letters that you had?
I don't recall ever discussing letterhead at all with any of my colleagues when we signed the letter.
All right. Did you have letters with regular letters that were printed and available with the seal but not his name on it?
Objection leading.
Did you?
Yes.
Your Honor, can we get a...
Yeah, that was sustained.
Thank you.
Rephrase.
Thank you. Tell me what kind of letterheads you had there.
I mean, there were many different types of letterhead. I don't even recall letterhead being a topic of discussion at all amongst our colleagues.
Well, did any of y'all do you have any knowledge or evidence or any belief regarding whether somebody messed with the letterhead of a letter?
None at all.
All right. If somebody's tried to keep saying it and saying it and saying it, would that be true or untrue?
Not true.
Now, after the 30th, and then on the 1st, did each of you attempt to visit with the Attorney General?
We did.
And what was his response?
That he was out of the office and would not meet with us, but that we could email him our concerns. He said that back to us in a text message.
All right. So then, after it happened, there was some public releases. Some of Mr. Mateer resigned, and so, correct?
Jeff Mateer resigned on, I believe it was Friday, October 2nd.
All right. Now, what happened?
2020.
What happened with you after these events? Did you resign?
I did not.
And what happened? What was your circumstances going forward?
I showed up for work.
And when you went to work, what were the circumstances?
Monday, October 5th, was the very first time I ever met a man named Brent Webster, who Attorney General Ken Paxton had hired to be the first assistant. We had a meeting previously scheduled at 9 a.m. that morning about the legislative affairs team, of which I was involved with. The very first thing that Brent Webster did in that meeting to me was he threw me out of the meeting.
All right. And then what happened next?
I went back to my office, and Brent Webster came into my office with a woman who was armed and kept threatening me to meet with him.
What did you say?
I said,
Objection, hearsay.
All right, fair enough.
Sustained.
Fair enough. So did you have a conversation with him?
I did.
And did you have a meeting with him?
I told Brent Webster that
Objection, hearsay.
That's fine if he doesn't want to know. That's
Sustained.
fine. Let me go after that conversation. How much longer did you stay employed with the Attorney General's office?
I was terminated October 20th, 2020, so that would be 15 days.
Briefly, can you describe the circumstances of the environment for you there before they ultimately terminated you?
It was an extremely hostile work environment. They had, like I mentioned earlier, Brent showed up in my office with a woman with a gun. They asked me to take my cell phone to the car. They removed me from access to Attorney General Paxton's schedule, which I oversaw. They hired apparently another scheduler without asking me. They sent a letter to the entire House of Representatives in response to a request by Jeff Leach that they did not even show me before they sent out, even though I oversaw the legislative team. I could go on.
All right. Let me ask you this. Can I have 576 and 3350? I believe they're in evidence, but I want to check before you put them up.
We don't have 576 on our
All right.
paper.
Matt, I think she's getting copies.
And what was the other number?
The two numbers were 576 and 3350. And I'll represent they are the letter that Mr. Leach sent, and the second exhibit is the response from General Paxton.
Let me give them a short moment to look at them. Any objection?
Just taking a look, Your Honor, just a second,
Sure,
please.
take your time.
Care about these. I guess no objection, Your Honor.
Admit Exhibit 350 and 576 into evidence.
All right, can we have 576, please?
Hold on, Mr. Harden, you offered 3350. Did you mean 350? Because what we received was 350.
Well, it was 350, I think. Well, let me look and see. Can I look?
Make sure. Sure. Go ahead.
Hard copy.
So it is 350, I overheard. So admit 350 and 576 into evidence. You may
Thank you,
continue.
Your Honor. Now, can you just, we won't go through the whole letter, but let's, if we can, scroll up, please. If you look at it, excuse me, this is a letter October the 9th, is it not? You were still employed? Were you still employed or not?
Yes, sir, I was still employed.
All right. And Mr. Leach, at that time, did you know what his position was in the House?
Mr. Leach was the chairman of a committee that had direct oversight over the Office of Attorney General.
Got you. And in that capacity, if we scroll up, please, actually go to the next page, I believe it is. Thank you. If you could do the top of it, again, at October the 9th. Can we go up? Just scroll up just a little bit. This last paragraph. I'll publish it with you to make sure I do it correctly. Irrespective of that decision, by way of this letter, I formally request that you provide a written report as to what specific steps are being taken by you and your newly appointed First Assistant Attorney General, Brent Webster, to ensure that the effective operations of the agency continue in full force and effect, without delay, without interference, and without interruption. I would ask that such a report be provided to all members of the legislature within 7 days. Now, in the paragraphs before, what did Mr. Leach lay out for him before he came to that final? If you could just describe it.
Mr. Leach appeared to be concerned about the state of the Office of Attorney General in light of the fact that our allegations had been public at this time.
All right. And so was this an opportunity to ask the Attorney General to respond to those allegations that had become public? Is that right?
That's right.
All right. Thank you. And now, Stacy, if I can have 350, please. That's 350. Let me have 576. Pardon me? All right. Now, if you would, look at this letter. You recall this letter?
I do.
And in this answer that he gives, how many pages? Scroll through it, please. Does he respond in any way specifically with Chairman Leach's request for an explanation and ideas as to what's going forward to correct it?
No, but he does lie to Representative Leach and the other members of the House.
Can you point out where it's untrue in what he said?
The very first line, he says that we made false claims. We did not make false claims.
All right. Anywhere else? Do you take issue with anything else?
On the second page, the second to last paragraph, Attorney General Ken Paxton says, OAG's regular business is moving forward at full capacity. That is 100% false.
All right. You're talking about the condition of the office after y'all left.
That's correct.
All right. I want to move on, but my one question to you is, anywhere in this letter that you read, does he really address Chairman Leach's questions?
He does not.
Okay. Now, what was the occasion exactly? How were you terminated? What were the circumstances?
Brent Webster, who was the first assistant at the time, called me into his office. There was another woman there named, I believe her name was Shelley Gustafson, and he asked me if I would like to have severance or if I wanted to be terminated. And I told him, Brent, I've done nothing wrong. I'm not going to resign to take severance. So he terminated me.
All right. Now, at some time after that, did you and 3 others of the senior staff file a lawsuit?
We did.
And is that lawsuit still pending?
It is.
Was there any attempt to settle that lawsuit? And if so, when?
There was no attempt to settle the lawsuit prior to Ken Paxton's reelection in 2022.
I want to ask you that. What date, approximately, or what month did y'all file your lawsuit?
It was sometime in mid-November of 2020, if I recall correctly. November of 2020.
All right. When you filed that lawsuit in November 20, you were about a year away from the election, were you not?
2 years.
2 years away from the election, excuse me. And during that period of time, what happened with the lawsuit?
Attorney General Ken Paxton tied up our case for 2 years, making the absurd legal argument that the whistleblower law does not apply to him. He filed what's called a plea to the jurisdiction, which effectively stopped discovery in our case for over 2 years.
So, as of the election of November 22nd, Had there been any discovery or ability to legally lay out the evidence or allegations in your lawsuit?
No.
Now, once the election in November of 2020 was over, or 22, excuse me, how was it that settlement conversations started? How did that get started?
Sometime in late January of 2023, so earlier this year, Ken Paxton's lawyers called our lawyers and said that they would like to discuss settlement and mediation. So the idea of settlement...
Stop. This is great. He's about to jump up. I want him to save his energy.
Thank you.
So he, at the time that they initiated settlement discussions, had there ever been any settlement discussions prior to that?
No.
Had there ever been any indication while the lawsuit was pending and the election was in the future, during that 2 years, was there ever any indication or suggestion that about a possible settlement?
Never.
Right. Do you know of any circumstances that changed and led to their reaching out to you to discuss a settlement?
Ken Paxton was reelected.
Was he reelected without knowing anything, without the public being told any of the real facts, and so in the discovery with depositions or so?
I would say it's even worse than that. I think Ken Paxton lied to the public for 2 years about our case. So not only did we not have discovery, he did the opposite and lied to the public about our allegations.
Let me ask you, if you can, then what I want to do is to go to Exhibit 460. I want to move to introduce 469 and 470, but I first want to ask a couple of questions about it. With the original settlement that everybody's heard a good deal about, was there a proposal that you actually personally, individually held up from reaching a settlement?
I did not go to the mediation. I never
hold
appeared.
on. We're going to try to do this in a question-answer way. So, was there a suggestion of a mediation sometime in February?
Yes.
All right. And who all went to that mediation?
My other three co-plaintiffs went: Mark Penley, David Maxwell, and Ryan Vassar.
And out of that mediation, did the three of them reach a settlement?
They did.
And what was this amount that they settled for?
$3.3 million.
Why did you not go to the mediation?
Because I did not want to settle the case.
Why did you not want to settle the case?
Because I wanted to be vindicated for what happened to me and my colleagues, and I did not want to settle the case. What happened to us should never, ever happen to any other public servant in Texas.
Objection, non-responsive at this point.
All right, let me move on. Moving on. Now, when you did you have conditions for money? Is there, how much money you wanted or anything?
No, sir.
Did you even give them a figure?
I never gave him a figure.
What happened after the mediation when three had settled and the Attorney General had settled? Did you see pressure or response or any attempts to pay you more money to get you to settle?
Yes, what happened is the parties came to me and said, okay, Mr. Brickman, what would it take?
Your Honor, I'm sorry to object. These are Rule 408 settlement discussions, number one, and number two.
Your Honor, I move to introduce Exhibits 469 and 470.
Was there any objection? I don't believe there was. Or
I need to see those.
We need to see those?
If these are Rule 408 settlement discussions, that would be my objection.
Do you have those exhibits in front of you?
I do.
For the record in the court, they're not in evidence yet.
I have 470 and 469.
Yes, sir. I move to introduce.
Same objection. Not only are they hearsay, but it's protected communications under Rule 408 settlement discussions.
Your Honor, there's nothing protected by these. These documents have already been public in numerous ways.
That's the trial is here in the court, not in the public. And in this court, Your Honor, these are inadmissible.
That's fine. The objection is invalid, Your Honor. These are documents that have now been
Give me a
published.
moment.
Sure.
Give me a moment.
I know. I know.
We looked at 408. We sustained the objection.
Pardon me, Your Honor?
I said, we looked at 408. We sustained the objection. I believe that was your objection.
That was my objection.
Rule 408.
Yes, sir. These were not, though, for the liability of the claim. I believe that's what we're speaking about as far as 408. These statements show what he himself, they offered him. If you look at
Your Honor, I'm going to object just to relating what the documents say and renew the objection that's already been ruled upon.
I sustained it. Move forward.
Well, did you have conditions for not agreeing?
Objection, same objection.
He has a right to tell what his objections were to settling.
Hold on. Just
Here's my problem.
You're talking over each other. I can't hear, and that means they can't hear. So what was your response to his objection?
I asked him for what was his response to their offer. This is an outward offer. This is not a mediation offer. None of this has to do with mediation now. They settled in mediation, and now the lawsuit's still pending. He rejected it. They came to him with the proposal.
Your Honor, again, he's
excuse me.
relating
Hold on, Mr. Busby, hold on.
This is the problem with the eating up the time, Your Honor. This is a really spurious objection.
I'll give him 2 minutes back here, okay? So your objection is, Mr. Busby.
Rule 408, textbook, this is improper, not admissible.
We just used up a minute and a half on an objection that has no validity.
You need to restate your question.
Sure. What were you making demands on them for whether you would ever agree to consider settlement?
Same objection, Your Honor.
Don't tell me what to do. No.
Overruled.
All right. Now, the answer first would be yes or no, and then, depending on that answer, I'll ask you the next question.
Could you please ask the question again?
Sure. Did you make demands on them that would have to be fulfilled before you would ever settle?
I did.
Same objection, Your Honor. That's Rule 408.
Your Honor, this is what he said, what his conditions were. I can even ask it, what were your conditions that you demanded before you ever settled?
Your Honor, Rule 408.
Mr. Busby, we agreed with you on the
Thank you.
first two objections on 408, not on this one. Overruled. Go ahead.
Thank you.
Is the question, what were my conditions to settle?
Yes. What were your conditions before you would agree to settle?
I told Ken Paxton in the Office of Attorney General that I would settle for 3 things.
Hold on, everybody. Let him speak, please. He's in
Sustained
charge.
on that one. Go ahead, rephrase. I sustained that objection. Rephrase it.
I wanted to know what your conditions were, not what you told them. Okay? Hold on. That's the basis of the objection. What were your conditions before you would ever agree to consider settling?
I had 3.
What were they?
Ken Paxton apologize for calling us rogue employees and admit that we did what we thought was right, was the first one.
That's number one.
The second one was the Third Court of Appeals had ruled in our favor that the whistleblower law applies, and I wanted him to agree not to move to dismiss that.
In other words, you had a winning opinion on intermediate court level, and you wanted an agreement that they wouldn't challenge that agreement, that ruling?
I did because I wanted future Texas public servants to know that the whistleblower law applies in this state.
All right. And what was your third demand?
That Attorney General Ken Paxton remove a disparaging statement where he called us rogue employees that was on the OAG website.
In response to that, instead of those conditions, where you offered more money if you wanted that instead.
Objection, Rule 408, Your Honor.
I'll sustain that objection.
Were you offered more money?
Objection, Your Honor.
Well, I was offered.
Wait a minute. He's got an objection on the table.
Objection. Sustained.
Well, did ultimately, were you willing to consider yourself, your own state of mind? Were you willing to consider more money instead of those 3 objections? Those 3 objectives that you had?
I was not.
All right. And was that communicated to the other side?
It was.
Now, ultimately, does Exhibit 470 set out this ultimate settlement that was pending, that is being considered by the House. Is that actually a document that has been presented to the House of Representatives?
It is.
So is it the settlement that is actually under consideration that the House, instead of paying right away, launched an investigation of?
It is.
So is that a public document?
It is.
Again, Your Honor, in all due respect, reoffer Exhibit 470, please.
Objection to 470?
Yes, Your Honor. It's as you can see, it's a mediated agreement proposed, which falls under a privilege, as the court knows. Moreover, it's hearsay.
Your Honor, excuse me, go ahead. I'm sorry. What I was going to say is that is tacked on to the settlement that occurred with the others. It was not produced by mediation. He never attended a mediation. He never engaged in a mediation process. What they did was they just simply put the final agreement on there once he agreed not to object, and they add on those 3 conditions that he required in order to represent the whole final settlement that affected everyone.
Okay, hold on.
Settlement is the problem.
Mr. Hardin, is this a public document?
Yes. I say that. Make sure I'm not overstating that.
Yeah, make sure you're not overstating that.
I'm getting, yes, it's being pulled off the internet, is it not? It's on the internet. And I would point out, too, I think 482B points out that the court can admit one either way on your own if you think it affects some type of issue in the case. I can assure you that Mr. Busby will be talking about having sued and being settled on cross. That would be something that would come under that. Thank you, Dick.
Overrule the objection.
All right. Now, may I have
The exhibits 470 and
Thank you, Your Honor.
469 are in admitted evidence.
All right. Now, just to be sure the record's clear, you never participated in a mediated settlement, did you?
I did not.
All right. Now, I want you, if we scroll down and look at the bottom of this, number 2 says what?
OAG will permanently remove this press release from its website.
And that press release was what? Is that the one in which you, what was that press release?
This was the press release where Attorney General Ken Paxton called me and my colleagues rogue employees.
Number 3?
Would you
Go
like me
ahead.
to read it?
Read it.
A recital in the settlement agreement will state, whereas Attorney General Ken Paxton accepts that plaintiffs acted in a matter that they thought was right and apologizes for referring to them as, quote, rogue employees, end quote.
And then number 4, would you read that?
The parties will not ask that the Third Court of Appeals opinion issued October 21, 2021 be withdrawn.
And is that the settlement that is now still pending before the House for approval?
It is.
You can take that down. Now, I want to, if
Mr. Hardin, about how long do you expect to go? Mr. Hardin, about how much longer do you expect to go? They've been on jurors have been sitting for 2 hours.
I'm hoping to do about another 14 or 15 minutes.
Can we take a break?
I think you can make it for another 14 minutes. Okay, I see nods from the jurors. Continue.
Thank you, Your Honor. If I can now, I want to move. There was an Attorney General report issued, was it not? That sometime in 21, setting out the Attorney General's side of what happened here?
In August of 2021, the Attorney General put out a report.
I believe Attorney General 127 is in evidence. I'm sure it is. But I just
It
want
is.
to be, I want to be certain.
It
Yes,
is. I put it in evidence.
All right. Now, would you identify the front page? If you read this report, can you just describe it for you in gentle descriptive language, please? Would you?
This is the report that the Office of Attorney General put out clearing itself of wrongdoing.
All right. This was represented as some type of independent report, right?
Yes.
And then you discovered, based on public statements, it was actually prepared by Mr. Webster, the first assistant.
That's correct.
Okay. In this report, have I asked you just to take three or four examples of things that you disagree with? Have I asked you to do that?
Yes.
All right. What I wanted to ask you is, in this report, how would you describe your reaction to it as accuracy in terms of what happened in these matters involving Nate Paul?
I would call this report a whitewash full of lies.
All right.
And omissions.
Now, if I may, let's just go over to page 5 and do this real quickly. If I ask you to pick 4 or 5 samples, can you just do that for me? And would you look on page 5 and see as to the first claim? What is untrue about that claim? You see
It
where you
says,
are?
on 2 prior occasions involving Nate Paul's interests, the Open Records Division sided with the government agency against disclosing to Nate Paul. That is not true. There was an Open Records decision that took no opinion as to the release of the documents.
What about the second claim?
If you start with the sentence, most relevant here.
Your Honor, I'm sorry to interrupt this witness. This witness was not involved in the open records decision. He was not involved in the MIDI intervention, at least certainly not directly involved. And for him to go through and, without taking away counsel's time, and go line by line a report about things that he wasn't involved in, that would not be proper. So maybe with respect to the second claim, maybe he has some personal knowledge, but everything else he has none.
That may be one of the more imaginative objections I've heard throughout this entire trial. What I would point out is, if I want to go through, he did have contact with the MIDI. Well, I just went by it because they've heard a million things about the MIDI decay. But all he's being asked is, are they true or untrue? He's got that wonderful art of screaming cross-examination. He can use every bit of it he wants, okay? But this issue here is simply, does he believe that is an untrue statement? He can challenge him as to what his basis is on cross.
Overruled.
Thank you. On this number 2 here, where it says A.G. Paxton's involvement is consistent with his predecessors and in line with his required duties and legal obligations as Attorney General of Texas. Most relevant here, the position taken by the AG in this litigation was adverse to Nate Paul and in support of a higher settlement amount to be paid by Nate Paul to the MIDI Foundation, as opposed to the prospect of continued and costly litigation that would disproportionately benefit the charity's court-appointed receiver and his lawyer. Is that a truthful statement?
It is not a truthful statement.
And you actually had an occasion to be asked the Attorney General to review the MIDI file at one time. All right. The third claim. This informal guidance letter regarding foreclosure sales written by Bangert was made in response to requests for disaster counsel advice from Texas Senator Brian Hughes during the height of the pandemic and not for the benefit of Nate Paul. Is that a true or untrue statement?
Objection, personal knowledge, Your Honor.
Object. Overruled. I'm sorry.
Thank you. Is that a true or untrue statement?
It is an untrue statement. The foreclosure opinion was for Nate Paul's benefit.
And in fact, the foreclosure opinion that said that foreclosures could not be conducted at that time because of the limit on people in the COVID situation, was that actually even totally inconsistent with what the Attorney General had just done recently?
It was this opinion was entirely inconsistent from prior opinions that our office put out. This was a time, sorry.
Are you familiar with a particular event some weeks right before the opinion of August 1st or 2nd concerning foreclosures.
1 month before this opinion came out, Attorney General Ken Paxton held a fundraiser in Dallas outdoors, and a month later issued an opinion saying that foreclosure sales could not continue outdoors.
Can we go to page 6, please? Look at the top. Kamak legally and properly exercised authority delegated to him by both AG Paxton and the TCDAO. Kamak was designated as outside counsel for OAG by AG Paxton, and he was also knowingly appointed as a special prosecutor by the Travis County DA's office. Is that a true or untrue statement?
It is false.
All right. Would you tell the jury whether these that you've labeled untrue statements that we've just gone through for just a couple of minutes, whether they are typical of this report or unique to this report?
I'm not sure I understand the question.
Are there other misstatements in this report?
There are many other misstatements in the report. These are just a few samples of the misstatements in this report.
All right. Your Honor, I've got to get a couple of things together. Can I renege and we take our break now? I will be through shortly after you return.
Yes. Before we break, could both parties come up for a second? Members of the jury, I have to conduct a hearing outside the presence of the jury. So you're on a break until further notice, and we'll call you back. I don't think it will take very long, but don't go far. Okay.
Now this is interesting, and one thing that we have not seen during the course of this trial.
And what this, if you've been in court before ever and covered a court hearing ever, served on a jury, there are times when the attorneys are going to argue about what evidence can be.
And the jury is frequently excused during those times.
It happens outside of the jury because obviously you don't want the jury to be tainted by hearing that evidence before it is decided whether or not that evidence can actually be admitted into court. And so that is what we take is going to happen here. And when this happens in a criminal case, it happens in front of the spectators.
Right.
So it will be interesting to see if
we're going to hear what this is all about,
hear it, or if the cameras are going to have to.
And there was no kind of prior indication of what that matter may be about.
No. Now there have been conversations, certainly earlier today, about some evidence, and they
Right.
said that they seemingly worked it out and that it was going to come up later. So we don't know if that is
Could be about that.
this,
Yeah.
and that was testimony that was involving testimony that Drew Wicker was testifying to, or if it was something. This was also when they came in today. They started late because they were having a disagreement, and they said that was going to be figured out this afternoon. And then we have the big question of Laura Olson and her
Right,
testimony.
and the timing of that, and if there's some issue there.
And so that's what stands out to me, just overall anecdotally, about Blake Brickman in his responses, which he doesn't, because the jury, the witnesses are not privy to what someone else has testified, how much time is left.
Right.
Those are not things that they are, they're under the gag order as well. They're supposed to be staying away from reporting and information about this trial. So we don't know if he knows that the clock is running out, but his answers are very direct, very matter of fact.
Yeah.
Very much he feels they were wrong.
Wrong, yeah. I was going to say, you can tell he's bringing a certain kind of anger, intensity.
And that he firmly believes Ken Paxton was breaking the law. His feelings about Paxton, I think, are very, very clear based on the tone of
Right.
his testimony, which is interesting.
But again, he's also revealing things that we have not previously heard testimony speaking to. So, for example, Blake Brickman is talking about the negotiation. Well, let's back up. Before there was the negotiation of the settlement, he contends that Ken Paxton took a number of steps to subvert the effort to obtain information as part of their whistleblower lawsuit, that he launched delays, arguing that because he was the Attorney General, he somehow could not be a defendant in a whistleblower case. A court ruled against Ken Paxton in that matter. It then, as my understanding goes, was going before the Supreme Court, or stood before the Supreme Court. It was before the state Supreme Court for a decision on that. But Ashley Brickman also saying that he was initially not party to a proposed settlement because there were a couple of things that he wanted as part of that settlement agreement, that tentative settlement agreement. Three things
he listed that he wanted as part of that settlement. Before we get to that, I want to note he also noted what was happening when he returned to work, that he was being removed
from duties,
and particularly he was in charge of having correspondence with lawmakers, and he mentioned specifically a letter, a response that was sent to an inquiry from Jeff Leach, State Representative Jeff Leach, who is one of the House managers. He's sitting right there, and he's saying that it was untrue. Some of the things that were included in the inquiry to Jeff Leach were not true, which is certainly problematic. When a lawmaker sends out a request for information, they have to be given truthful
There's
information.
also, to your point, Ashley, a couple of other important things that happened before this settlement, tentative settlement was reached, and that is the Attorney General's office drafted their own report responding to the whistleblower allegations that
they did an investigation, and it was supposed to be an independent investigation.
An independent investigation of themselves, essentially. And Brickman citing a number of ways that he said that independent investigation of the Attorney General's office into the conduct of the Attorney General was replete with errors. And one of the things, actually, that
it wasn't independent.
And that it wasn't
and
independent.
And that it was, in fact, the office that did it.
And one of the things, and we saw this testimony arise yesterday, and that is one of the things that report stated was that Ken Paxton did not appoint a special prosecutor, that the special prosecutor, that whole thing again, that the special prosecutor,
the
Brandon Kamak situation, and that the appointment of Brandon Kamak was actually done by the Travis County District Attorney's Office. Yeah. But Blake Brickman then going on to say that he was initially not part of that proposed settlement because there were three things that he wanted from that. But I think first and foremost, was an apology for being called rogue employees, and not just an apology. Early in this whole saga, Kim Paxton released a statement that still resided on the official Office of Attorney General website. And as a condition for this settlement, Blake Brickman wanted that statement stripped from the Attorney General's website, which, by the way, it has been stripped from the Attorney General's website.
And the third thing that he wanted was for the Attorney General not to appeal the decision that stated the Attorney General was not
immune,
excluded
yes,
from and was immune to a whistleblower lawsuit, because he said he wanted future Texans to know who might find themselves in his position and the position of the other whistleblowers that, you know, the Attorney General was not above the law and could in fact be held, you know, in their eyes accountable for those types of actions. I thought it was interesting, Tony.
Oh, are we about to say the same thing?
Okay, let's see. Let's see.
Well, I was going to say that the response to Blake Brickman's demands request
we were going to say the same thing.
Is that Team Paxton said, is there an amount that he would be willing to settle for
in lieu
of these other us meeting the others' demands? Yeah.
Which really takes you. It causes pause. Certainly for me to hear that. And he said no.
He said no.
He said no. There's no amount of money I want.
The correspondence from his attorney is actually entered into evidence. I can't find it. I was going to say, but there was a very terse response from Blake Brickman's lawyer to the question of would he be willing to, and the answer was just like a one sentence, like no, he would not.
Right.
You know, like period, end of story.
It speaks very clearly to, again, the directness of the testimony that we're hearing from, you know, from him himself. So I want to know, so we talk about this hearing that has to happen. We're seeing Tony Busby on the floor right now. He's actually talking to Jeff Leach, who we were just talking about. So we could assume that if Busby is in our presence, and you can also see Rusty Hardin speaking with his team, that hearing has not happened yet, and really no word on when things will get started. I mean, telling the senators that they are sort of on a break until further notice, that he doesn't anticipate that this hearing will take long, but not giving us a time. I think it's certainly worth noting the clock. It is 3:56, which means at any point
if you've been waiting with bated breath all day long
for Laura Olson to take the stand, it can now happen according to the rules at any time. We were waiting for 3:53. That was when she was served notice yesterday, and the defense attorneys given notice that the intent to call her to the witness stand was 3:53 yesterday. It's now been 24 hours pursuant to the rules, which means she can be called up. But Tony, how much time does the prosecution have left?
I mean, it's dwindling. I don't have the number in front of me, but I know,
I was doing some math.
Yeah, I saw you over there.
I'm calculating. So when we started the day, the House only had 5 hours left, 5 hours and 15 minutes, not only to call their witnesses, but to cross-examine any of the defense's witnesses. And so because they could not call Laura Olson up, they chatted with Ray Chester. He was the first witness that we listened to today. He is an attorney who represented the Mitty Foundation. We then heard from Drew Wicker, the executive aide or the body man to...
Who I think we can say safely was definitely a star witness for the House impeachment managers.
And someone who, you know, to use the phrase that was given by Tony Busby, loves the Paxtons. That Angela Paxton took on a mother-type role for him because he was away from his own family so much, because he was with General Paxton so much.
With Ken Paxton, he said, he testified to this more than Angela Paxton
more than anyone else, that he was with him more than his own wife. And then James Blake Brickman. And so granted, you know, there's delays, there's a lunch break, there is the cross-examination, but the House has easily burned through 2 I would say 2.5 hours of that 5-hour time.
Yeah.
And we're still, when we return, we'll have Brickman still on the stand. And so, you know,
you can imagine that they're trying to. I mean, I'm thinking about how they maybe calculated all of this in terms of, you know, how they used their time prior to their stated effort this morning to put Laura Olson on.
And the other thing is, do they themselves, are they willing to use all 24 hours of their time for themselves and
so that they can't cross-examine?
And not cross-examine any of the defense's witnesses, and that's if the defense intends to call witnesses. Now, Dan Patrick has noted, and certainly Tony Busby has made statements, and I say Dan Patrick noted because he talked about the notice that was given to one of the defense's witnesses yesterday. So we know that they've served
They plan
those
to call
notices
at least, somebody.
for witnesses to appear.
Right.
But whether or not they're actually going to call them, the burden of proof is not on
Kim
the defense.
Paxton. Yeah.
It's not on his defense team to prove or disprove any of these articles of impeachment. It relies solely on the House managers, and they are there to try to plant seeds of reasonable doubt.
Yeah. So just going back to the whistleblower, because the pause we're having now is in the testimony of Blake Brickman. Sage, I'm wondering if you can punch up. I would like to go through the articles, if we can, that deal specifically with the proposed whistleblower settlement. Ashley, do we have
Sage
the number?
is feeling like Eric right now. She's back there.
Exactly. Sorry, Sage. Yeah.
Eric and Sarah. It's article number 8. Sage is the one that we would like to look at first. And so article 8, I'll start while we're waiting for her to find that and pull it up for you all to see. But it's
they're like three.
Yeah, there's three of them related to the whistleblowers and the settlement and the report. So those things that we've talked about. Article 8 specifically says that, there it is right there, that Ken Paxton misused his official power by concealing his wrongful acts in connection to the whistleblower complaints. You'll notice that's the quotation. That is directly what is written in the article. Those are not Ashley's words. And that basically he entered into this agreement with the whistleblowers using public funds to cover up what he had done, and this was preventing voters from finding out the truth.
Well, and Blake Brickman spoke to that as part of his testimony, by the way. He said that the delay tactic that Kim Paxton engaged in was designed to stall their whistleblower settlement and stall their effort at discovery until the conclusion of the November 2020 election. But just continuing with this specific article of impeachment, it also alleges that Kim Paxton deprived voters of the opportunity to make an informed decision. So that's one of the 3 impeachment articles dealing specifically with this proposed settlement, of which Blake Brickman is a party to.
Yeah, and also Article 7, when we're speaking specifically about the whistleblowers, and I know Sage is working to get that pulled up for you, but Article 7, it argues a misapplication of public resources, and the argument is that Paxton misused public resources that were entrusted to him and his office to conduct what the House managers call a sham investigation into the whistleblower complaints. That basically he launched a report where he said, we're going to investigate these allegations against me, and that they then published the report with what they described as misleading and false statements in Paxton's defense, defending Paxton.
So you can see there in a pretty transparent way, the prosecution is using Blake Brickman right now to shore up in their minds these 3 impeachment articles dealing specifically with the whistleblowers and the proposed whistleblower settlement.
Mm-hmm. The final one, Article 6, related to the whistleblowers, is disregard of official duty. And this article, it is directly dealing with the termination of the whistleblowers, alleging that Paxton violated the whistleblower law, Texas's whistleblower law, when he decided to fire them. Do you want to talk a little bit about how Brickman described his firing, Tony?
Yeah, I mean, he talked about, this being conducted by Brent Webster, who was appointed pretty quickly after
Oh,
Jeff
yes.
Mateer left. Brent Webster, by the way, was also previously an employee of the Williamson County District Attorney's Office. He was a prosecutor in that agency prior to getting this, frankly, plum assignment as the first assistant to the the Attorney General of Texas. But Brickman talking about how Brent Webster was stripping him of his duties, coming into his office with a woman he didn't identify, but someone
Except to say that she had a gun.
Yeah. So that was certainly
And
part of
pressuring
that.
him to meet with him. The woman was there, and they were pressuring him to have a meeting with Webster.
But 15 days after the whistleblowers went to the FBI to report Attorney General Kim Paxton, Blake Brickman was terminated from the agency and is, as we mentioned, a plaintiff in the lawsuit.
And this, again, you'll notice one of the other sort of prongs, if you will, in this article is that they allege Kim Paxton sort of went on this campaign to dismantle their professional reputations, to spread these things, and that's why you hear he was so adamant about having this apology issued to him, that these are not rogue employees, these are not people who just as certainly the language that we have heard from Paxton in post this in this this witch hunt, or what he describes as the establishment or rhinos, that's not. These people, these conservative attorneys, these conservative Republican attorneys did not want to be seen as that.
So if we could just kind of go back to the Senate floor, there goes, by the way, Johnny Sutton, who just walked across. Well, he just left the frame, but he is an attorney representing some of the whistleblowers, a former federal prosecutor whose name has been bantied about in this proceeding. Actually, one thing that's striking to me is that I was, I guess, under the mistaken belief that whatever hearing the lieutenant governor, the presiding officer, was going to have was going to be in a public space at the bench, but that does not appear to be what's happening. The room is essentially vacated at this point, so it's a little difficult, I think, to know what's happening at this moment. What's happening and why?
To see. I'm looking to see if the court reporter is sitting at her desk. And while I can see her desk, I can't see it well enough to know whether or not a person is sitting there.
Is that Rusty still standing there? I can't.
It's a little hard. Rusty is.
Yeah, Rusty still is in there.
I think Busby is still, that is Busby standing on his side. So
it's a little tricky to know.
So it is a little tricky to know, and I think also one of the things that we might want.
And if the lieutenant governor just needed a bathroom break.
If he himself needed to grab a snack and a drink of water, it certainly is hard to be sitting down throughout all of this. Unlike the senators, he doesn't get a chance to stand up at all and take a moment. And so, we don't know if that evidentiary hearing, if that is in fact what it is, or whether it is a different type of hearing. He really didn't say what he had to rule on. He just said he had to have a hearing to rule on something. If you hear me flipping through pages here, I'm looking over my hard copy of the notes.
But again, just in terms of the testimony today, it has certainly been a big day. As someone listening to the Drew Wicker testimony, particularly the timing of the invoice to Kim Paxton, the payment of the project done at his home. Ashley, you and I were talking earlier. I think that was largely left in the eye of the beholder, whether or not
I would agree.
whether or not an invoice was fabricated after Kim Paxton learned that his employees had gone to the FBI or not. That was sort of just left lingering in the air. Certainly Tony Busby argued that was not the case, and that Kim Paxton and Angela Paxton paid out of their accounts for that home remodel, that kitchen remodel, after receiving an invoice dated September 1st, 2020. So,
And we say out of their own accounts they received a insurance claim
correct.
amount in the exact amount for the renovation that was done.
126.
121,617. That
yeah.
number, $121,617. I think that's going to be burned into my head for a while now. That was the amount of money that they received from USAA, from their insurance company, for the water damage to the master bedroom of their home in Terrytown.
And there was correspondence between Kim Paxton and the manager, the trustee, essentially instructing that person to pay the invoice. So, Ashley, I'm not sure exactly what is happening right now, or how long this break could go.
No, so and it's interesting. So Dan Patrick said earlier, before Brickman took the stage, my goodness, before he took the stand.
It's a stage, all right.
Indeed. Before he took the stand, he said the intent was to have about a 30-minute break at 3:30 until 4. But then we had Brickman, and that testimony carried over. That's a Senator Jose Menendez walking on the that you see there.
Blue
And
suit,
so
yeah.
I don't think, or certainly that this would lead us to believe the senators are allowed to be on the floor right now, which they will not be allowed to be if this hearing is going to happen in front of all of us, in front of the public. So, yeah, we're just sort of waiting to see what exactly will happen here. Let's rewind a bit, Tony, because we seemingly have time, and talk a little bit more about some of the testimony we heard, and as it speaks to the articles of impeachment, because it was interesting, I think, to see Drew Wicker's testimony, and we had Tony Busby pulling up the article of impeachment as it is related to the renovation of the Paxton home, and whether or not that was done by Nate Paul as alleged by the House managers, and asking him, did those things happen? And that's kind of been his MO throughout this.
Right.
And so it was also interesting to see yesterday Dick DeGuerin take that strategy, and Busby started that strategy with another witness, but then abandoned it. But then DeGuerin kind of picked it right back up. And so that's an interesting, I think, thing to see them do. And certainly the legal analysts that we've had join us, we had two local Austin attorneys join us over these days. And that for them to say that really stood out to them as well, that this is a question for the jurors that they're then having the witnesses answer.
And just to rewind the tape on Drew Wicker, in case you missed his testimony, which I think it's safe to say ate through the bulk of the day. Drew Wicker grew up in the DFW area in a town called Prosper. He is definitely a conservative, a person who has been involved in conservative politics, certainly in college. At Southern Methodist University. He then went to Georgetown. Then he moved to Austin, where he served as Ken Paxton's executive assistant. And again, what was so important about his testimony is that the assertion that Ken Paxton had his kitchen remodel paid for by Nate Paul originated from Drew Wicker. Drew Wicker talked about observing the relationship between Ken Paxton and Nate Paul. He discussed 3 lunches, including one at Polvo's that he attended. And he talked about multiple occasions in which he was asked to transport materials, including a manila envelope with materials several inches thick between Ken Paxton and Nate Paul, including a CD with information that they really did not discuss or get into much, the contents of that CD.
But certainly we had Tony Busby kind of alluding to the idea that maybe what this was, that, you know, what was in the envelope was just an invitation to a fundraising event, and that might have been what was in the envelope. That was certainly something that they tried to, again, plant a little seed of doubt, and we'll have to wait to see where that lands with the jurors.
But then Drew Wicker began talking about concerns that he was having in 2020. He talked about he was the keeper of Ken Paxton's calendar, and he talked about how Ken Paxton was dropping his security detail in 2020 and not including entries into his calendar, including multiple Nate Paul meetings. Wicker said that he was so concerned that he did raise the issue to his supervisor. And part of the reason, Ashley, that he raised the issue to his supervisor, he said, is that he wanted counsel. He wanted advice about how to talk to his boss about this.
That. Because, and certainly because there was a safety concern. You're having the Attorney General of Texas going about the city without a security detail. That is concerning for the people
who work for him,
wanted to keep him safe, whose job was to keep him safe.
He Drew Wicker went on to say that he was, in fact, at the Paxton home on 3 different occasions when he heard the contractor, Kevin Wood, who is of Austin, say that he would need to check with Nate about the financial implications of the home project.
Well, that he heard that 3 different times during one conversation. He heard the phrase, "I'll have to check with Nate," 3 times being stated in one conversation. So whereas we've sort of had this, maybe you misheard, or maybe you did not hear it clearly.
You got confused,
right.
yeah.
Aaron Epley was sure to point out that this was something that he heard stated by the contractor on the ground 3 times during one conversation with Paxton.
And Drew Wicker was not equivocal about hearing that. I mean, it wasn't like, I thought I heard it or I think I did. He testified strongly that is what he heard. And then at the conclusion of his testimony, Ashley, there was this, moment where the House impeachment prosecutor, Epley, unraveled this suggestion based on metadata from an invoice that seemed to suggest that the invoice on which Ken Paxton paid that amount of money was created on October 1st, the same day that Ken Paxton would have learned that the whistleblowers went to the FBI.
And let's talk about that for a moment, because before that happened, before she presented that metadata and had Wicker read it, Tony Busby seemingly put Article 10 to bed as having not happened. There was.
I mean, the Ken Paxton supporters were cheering. You couldn't literally hear them, but you could see, for example, on social media that they wwere like, case closed. We won.
Because essentially it was that Ken Paxton had sent this payment to, that Ken Paxton received an invoice. The invoice had a due date of September 30th. And that Paxton sent a text message to his blind trust to tell them to send the money in that amount. And so that was conceivably done before Ken Paxton ever even knew that the whistleblowers had gone to report him. And so, that was going to be hard to come back from, right, in terms of Team Paxton, if you're a Paxton supporter. So to then have Aaron Epley say, well, but when was the invoice made?
Yeah, exactly.
But when was that, because you can put a due date on an invoice at any time. When was it made? And so I think that just leaves, honestly, it'll be interesting to see how they address that in closing, in their closing statements or their rebuttal
and what the jurors
arguments.
do with that.
Right, because if you are inclined to believe that Ken Paxton, that the renovation, the insurance company happened to give them the exact amount of money that they were to be charged for the renovation down to the exact dollar amount, and that it was then submitted to him, and that he went ahead and authorized that payment and then received an invoice, maybe perhaps has a receipt or whatever, that he had been in contact. If you're inclined to believe that, then
maybe you're good with it.
Maybe you're good with it and you think acquit on Article 10. But if you think that perhaps there was an inkling of something happening, because we also know that Drew Wicker confronted, and I say confronted, he talked with Paxton about overhearing them say, "I'll have to ask Nate," that in fact, I'll have to check what Nate actually is the quote, but that when he heard that, he did in fact go to some of the top aides in Paxton's office for advice.
Correct.
What should I do about having heard this? And they said you should talk to him about it and ask him about it. And Paxton said, no, that's not what you heard. But that information, we want to point out, Drew Wicker is not a whistleblower, but that information that was given to them, was then used by the whistleblowers as they saw as evidence and reason.
I mean, one thing that is striking is just the number of kind of red flags around, that multiple people, from his executive aide to his top deputies, I mean, based on their testimony, did spend months sort of questioning and warning Ken Paxton about his association with Nate Paul.
And despite those warnings from your trusted, your trusted aides who
advisors,
people who had become friends from Drew Wicker, whom you looked at as a son, to continue down the road with and having, contact with and meetings with Nate Paul, I think it speaks to the why, and that's the question that so many of us had going into this.
And whether or not, Ken Paxton did anything illegal or unethical is certainly not for us to decide,
not for us to weigh in on.
But I think we can definitely say that over an extended period of time, Ken Paxton appeared deeply committed to his relationship with Nate Paul.
The testimony shows that. We have heard under oath, sworn testimony by these people who were allies of Ken Paxton, not just Paxton supporters or, they talk about actions they took and that they wanted to take to protect their boss, to protect Ken Paxton in all of this. To hear what they're saying, Tony, at this point, at 4:21, where you can't help but wonder if the hearing is happening.
If it's happening behind closed doors.
In, perhaps Dan Patrick's chambers, rather than something that's going to happen out in the public. Now, we do see some of the representatives who are a part of the House Board of Managers standing. So towards the right of your screen, the gentleman with the white hair, that's Representative Charlie Guerin, and he's one of the House Board of Managers.
A Republican.
A Republican. House Board of Manager who's standing there. And then on the other side, I believe that's Anthony Osso, who is one of you can see him standing there. He's one of the defense. And there's Rusty Hardin walking around. So maybe this hearing, you guys can't see Rusty Hardin, but we have a couple of views up of the Senate, and we just saw Rusty Hardin walk across the Senate floor.
Didn't seem to be in a hurry to get to a hearing, by the way.
So perhaps I'm seeing another Ann Johnson, Representative Ann Johnson, who is
an alternate view,
who is one of the House Board of Managers and has been, and I will say played a really pivotal role in the impeachment.
The
impeachment vote. There's another view.
Played a pivotal role
there too. So,
and also delivered very impassioned comments on the day that they unfurled these impeachment articles. Ashley, I'm wondering if we too should take a break and come back as soon as we get more information about what is happening on the floor. Looks like we
okay.
are.
I'm hearing, let me say this. I'm being told that the court reporter is in the Senate chamber. So
Maybe the hearing is
that-
going to happen.
maybe
and
the hearing is going to happen in a venue in which we will be able to be party and privy to it and get a chance to watch it. This is the video you're seeing from our photographer, Scott. I guess that's the court
There she
reporter right
is.
there.
Yep.
So him zooming in. Thank you, Scott.
So we can only
for
assume that Dan
listening.
Patrick is probably taking a much needed break himself.
Sure, and that they'll come back in and have this hearing. And the court reporter is important because any hearing that happens, anything that he rules or no, it can't happen outside the presence of the court reporter. She has to take notes on and record what is being said for the record.
Which, by the way, when we talk about the record, very often in any sort of case, be it civil or criminal, I mean, the point of the record is in case one party wants to challenge something that was litigated during a trial. If there are appeals to be had, appeals being sought. In this case, obviously there's no one to appeal to, but the record will almost certainly become a historical document.
It is in fact a historical document. We've not seen the impeachment and an impeachment trial of a statewide elected official in the state of Texas in more than 100 years. 106 is the last time it happened. Is that right, Tony? 106 years ago?
Yes, exactly. 1917.
17.
Which
Paul-
did result in a
removal
from office.
Yeah, Governor Paul.
Well, I think it's more nuanced than that. He was convicted and then I think resigned after. It said he framed it as his own resignation after he was in fact convicted.
And then he was convicted on criminal charges related to what he was impeached for. But lo and behold, his wife, Ma Ferguson, then becoming the first woman to serve as the governor of Texas after he was impeached.
And speaking of the potential for criminal charges, we also know that this case does remain under federal investigation. Many of the allegations that the whistleblowers took to the FBI did trigger an ongoing FBI investigation. We've heard from testimony yesterday from Missy Carey, who was Ken Paxton's chief of staff, the first female in that position in the history of the agency, and the first person to rise to that level after serving as a line attorney in the ranks of the AG's office. She confirmed for the first time on the stand that she had delivered testimony to a federal grand jury in 2021 after obtaining a subpoena. But again, we also know more recently through our own reporting that people have testified before a grand jury in
People
San
close to
Antonio as well,
Paxton.
people close to Paxton, as that grand jury effort continues in this matter.
So just to kind of sum this all up for you, Lieutenant Governor Dan Patrick said he had to rule on a motion. He told the senators they were going to take a break until further notice, no time frame given here, saying he didn't anticipate it would be a long time for him to make his ruling and hear this evidence hearing. We, by all accounts, assume that it is going to happen before the court because the court reporter is seated here in her seat at her desk.
We know that senators are not invited to this hearing.
Senators are not invited. You see Senator Sparks walking back on the floor. Some of them walking on the floor to get their belongings, but they would not be allowed to be in this because it's a hearing about evidence, and he's going to make a decision about whether or not some evidence should be admitted. And so we ourselves are going to take a bit of a break here, and we will be back as soon as we learn what happens. You'll be able to see sort of
just
this
keep watching
feed
the
up.
stream.
Just keep
Yep.
watching the stream. You can check back in. We're not going to kill or we're not going to cut the stream for you, so you'll be able to see when stuff happens, but you just won't hear our voices. We're going to ourselves get a sip of water.
Exactly.
As we're waiting for this to happen, and of course we'll bring you the latest on KVUE News at 5 and 6, but always here with our gavel to gavel coverage on KVUE Plus. So just stick with us.
Yep, and we'll see you shortly. Welcome back. After what has been around a 50, maybe a little bit longer minute break with Dan Patrick taking this recess to say that he needed to have a hearing of some nature. He did not describe the reason for the hearing, but said that it needed to occur. And it's unclear, frankly, if the hearing occurred during this break or if he is about to conduct the hearing. He did ask that senators clear the Senate floor for this hearing. But again, the exact nature of the hearing or what is to be discussed or worked out was not described by the Lieutenant Governor. He sounds like he's about to give us an update and is gaveling back in. Let's go to the Senate floor.
Bailiff can bring the witness back in.
Again, this is testimony from Blake
Members,
Brickman.
for the record, the House Board of Managers called Laura Olson. She is present but has been deemed unavailable to testify. As soon as we get the witness in, we can continue.
Like that.
I said the House Board of Managers called Laura Olson. She is present but has been deemed unavailable to testify.
So a striking development there. Lieutenant Governor Dan Patrick has announced that Laura Olson was called to testify but has been deemed unavailable. So presumably...
The statement has been made by the court. It says what it means.
That is what he's
Both
been
sides have
doing.
agreed to that statement. Both statements have agreed to that statement.
So now we're returning
Did
to
not
Blake
mean to be
Brickman.
short with you, Senator. I'm not amplifying the orders we give. It's stating what both sides agreed to in writing. Mr. Harden, you can continue.
Thank you, Your Honor. Stacy, well, first of all, very quickly, let me ask you, were you familiar with the House situation in terms of the Attorney General and the fact that it was having construction and they had to move out for a while and so on? No, microphone, and there you go.
Yes, sir, I was.
All right. And you've testified earlier that the Attorney General's office was right next to you. In addition to that, would you regularly get reports from and follow information from Mr. Wicker?
Yes, the scheduler and the executive assistant, Mr. Wicker, both reported directly to me.
And do they give documents to you as to what they're doing or anything like that?
They did, and we met weekly.
And so from your own personal knowledge, do you know when the Attorney General moved back into his house?
I do.
When was that?
Sometime around mid-July, around the 18th or 19th of July.
All right. Now, were you also aware of the name of who was the company that was doing the work on it?
Recently, I became aware of that company's name.
Well, at some time, did you actually do some research into that person on your own after you were terminated?
I did.
And at the end of the day, the names, you of course know Mr. Nate Paul. Were you familiar with the name Kevin Wood?
Yes.
And were you the name of a person who went by the name of Raj Kukar?
Yes.
And have you reviewed certain materials concerning those people's names?
I have.
I'm going to ask you, if you would, Stacy, this exhibit is already in Your Honor. I think the defense put in Exhibit 134 is already in. And they put it in mass, and that production included the pictures. I believe it was the production by Mr. Wood. Yes, okay. Could you put up Exhibit Wood with bait stamp Exhibit 134.050? Could you put it up with the bait stamp 6211, please, Stacy? Now, I'm going to publish it for you and ask you a couple of questions. First of all, Kevin Wood, were you familiar with the fact that he was the main worker or in charge of the work that was going on at the house?
Yes.
I won't object, Your Honor. He said he learned this later. He had no personal knowledge at the time this happened.
Sustained.
This particular document that the defense put into evidence says, Nate worked yesterday 7 a.m. to 10 p.m., got home, and fell asleep. Going right now to start guys on K job. Mr. Kujar's last name begins with a K, does it not?
Raj Kumar.
Kumar. And Mr. Kumar's company is what?
Cupertino Builders.
All right. Then guys at Ben White Concrete ask for help. After I check on the 3M guys, I can get email more detailed schedule. Does your house look okay for Father's Day tomorrow, or does it need cut? And this particular email produced by Mr. Wood was sent to whom?
To Nate Paul.
Now, it lists a series of things here. Would you read those off of things that are to be done?
Sat subfloor. Sunday subfloor.
Slow down. Go ahead.
Monday restore old floor. Tuesday new floor. Wednesday new floor, landscape front and fix irrigation. Thursday new floor, new fans and fixtures, finish landscape. Friday finish new floor, finish electrical. Saturday seal all floors up, Sunday clean up.
Can you imagine any reason that the man doing the work on the Attorney General's house would need to be informing Nate Paul of the schedule and the work being done?
I cannot.
I'm sorry, Your Honor. He's assuming that this has anything to do with Ken Paxton's home. This is not the witness for this. I object.
These documents, these are actually taken. Let me make sure I'm not falsely accusing him. Hold on. Is he seriously contending? We'll take some time out. I don't want to. This is an exhibit he produced. He used photos in this deal. He wanted photos of the house. My question is, I don't want to falsely accuse Mr. Busby, but is he seriously, as an officer of the court, contending there is any question as to whether or not the documents in Exhibit 134 have to do with Mr. Paxton's house?
Your Honor, I'll respond to that. And yes, he has accused me of a lot of things throughout this trial, but I'm not too concerned about it. You can see from the email itself, a fair reading is this man is working on multiple different jobs, and this witness has no ability to tell us what these things and whose job that is. This guy was also apparently a landscaper and was doing different jobs, and we don't know. We know that some of the pictures, obviously, are of the kitchen in the Paxton home, but we don't know, and this is not the witness to be asking about the renovations because he doesn't know anything about the renovations.
My question was, is he contending seriously, he hasn't answered it yet, that these documents do not have anything to do with Mr. Paxton's house? If so, we'll try to prove that up later. I don't believe he said that.
I didn't come here to answer his questions, Your Honor. Thank you.
It's not his, you're not asking him questions. He made an objection. He explained it. You made an objection.
Thank you.
I'm going to sustain the objection.
Is the court ruling? All right, thank you. If I can now, Stacy, would you put up exhibit with the date stamp 6212? The last exhibit was 620. This one's dated, actually, I thought 622 was the next exhibit. These would be 6212, 6215 is what I really mean to have up now, Stacy. I'm sorry. The date of this one, please, sir.
July 4th, 2020.
And this one is from Mr. Nate Paul to Mr. Kevin Wood, is it not?
It is.
Nate Paul tells Kevin Wood what?
Great. Can you send me pics?
Kevin Wood responds what to him?
Guys just finished applying second coat of sealer.
Stacy, I'm sure that it was wrong, my mistake, but I wanted to see if '6211 and 6212, if you would tell me which you put up first, and I'll put up the other one now. I don't know whether I gave you the wrong number. Pardon me? All right. Is that what you put up first? All right, thank you. All right, then 6212, please. This is on the 22nd of June. And to Mr. Kevin Wood, he's responding on top of an email from Mr. that we just read on the one on June 20th. Do you see that?
I do.
And this is Kevin Wood to whom?
Raj, Nate's guy, Raj Kumar.
All right. Raj Kumar is the president or CEO of the company that did the renovations, correct?
Correct.
And then below that, this is he's forwarded Kevin's to Nate Paul. So essentially, what's happened with this email? How does it begin? Kevin Wood forwarding the email, you tell me.
The initial email is Kevin Wood to Nate Paul on June 20th, and then it's forwarded from Kevin Wood to Raj Kumar on June 22nd of 2020.
So we now have we not, or have we, communications between the man doing the actual on-the-site construction, updating Nate Paul, and then the man on the site doing the construction, communicating with the owner of the company that's doing the construction, correct?
We do. That's correct.
And so in these messages back and forth, if they are in fact communicating about the lieutenant,
No problem, Senator. No problem, Senator.
I'll put general if I have to. The attorney general, the people that were doing the work on the attorney general's house are all communicating among themselves, are they not?
That's correct.
And they're communicating about the attorney general's house, are they not?
That's correct.
Now, I want to look at, if we can, 6216, please. Actually do 6215, Stacy, please. Now this one is dated, the other two were the 20th of June and the 24th of June. And this one's dated July the 4th, is it not?
That's correct.
And it's from whom to whom?
From Kevin Wood to Nate Paul.
And Nate Paul says what to Mr. Kevin Wood?
Great. Can you send me pics?
And he's saying that in response to Kevin Wood telling him what on Saturday, July 4th?
Guys just finished applying second coat of sealer.
Stacy, 6216, please. On July the 4th, in response to an email asking from Mr. Paul, can you put together, please, Stacy, side by side, 6216 and 6215? So, on July the 4th, on the left, the one we just went over, Nate Paul asked Kevin Wood to send him pictures of the work they're doing, correct?
Correct.
And then if you go over to the right, Kevin Wood does what? On the same day, on July the 4th.
He sends him the photos.
He says, does he not? This time, Kevin Wood includes Nate Paul and Raj Kumar on both of them on multiple pictures of the house, correct?
Correct.
Do you have any idea why those three would be communicating like that if Nate Paul had nothing to do with the Attorney General's house?
Objection, speculation.
Sustained.
Now, after you were terminated, did you start doing some of your, and of course y'all had a lawsuit starting when?
November of 2020.
Okay. Did you yourself start looking to see if you could find information that would help your lawyers and your lawyers for information and so on? Did you come into discover a receiver's report that had to do with Nate Paul's businesses?
I did.
And did you, in fact, yourself obtain that report and give it to us?
I did.
I'm going to show you what it has been and ask that Stella submit to the court on the other side. This is a new exhibit, Your Honor. Now, without talking about the internal parts of it, what did you discover? How did you discover this receiver's report, and where was it filed?
Your Honor, I'm sorry to interrupt. This first time disclosed. Number two, he's already admitted that he didn't have any personal knowledge of this. He just went and found it. He's not here as some kind of investigator. He's supposed to be telling us what his personal knowledge is of things that occurred at the AG's office. What they just handed us looks like to be file stamped October 31st of 2022.
Your Honor, excuse me.
He was out of the office long before that.
All right, Your Honor, if I may respond.
Yes, you may respond.
This is a receiver's report filed in litigation in Harris County in the 165th Judicial District Court. And what we have and what you have is a certified report, certified public document. It's filed and now certified that it is a public record, and it comes in under 8038A3.
Your Honor, first it has to be relevant.
Let me just
I thought you were finished. Go ahead, sir.
Excuse me. Let me finish, please. Public records, and it has factual findings from a legally authorized investigation. And the relevance of it is it deals with the extended cross that Mr. Busby went through about the house and whether or not it was legitimate and all of that. And that is addressed, not the house, but the investigation. And clearly, I respectfully suggest it's admissible as a certified public document.
Mr.
Excuse me. Do not answer. Mr. Harden, forgive me. I did not understand what you said just now.
Oh, okay. That would not be
Give me
the
one
first.
more try.
Oh, sure. And that won't be the first. This is a certified public document. It is admissible without a sponsoring witness. If it is relevant to the issue, the matter that we're seeking to introduce it in, then it comes in under 803C without a sponsoring witness because it is certified as a public document. Comes in under the public documents exception to the hearsay rule. And in this particular case, the reason it is relevant, I will refer the court, perhaps would help you if you look on page, if we use and so that you can yourself look, you will look at page 84, base stamp Brickman down below, 84, Brickman 85 in particular. And it has to do with Mr. Nate Paul. Go ahead.
Mr. Harden, I don't see an 803C. What am I missing?
Okay. Okay, I'm sorry. She's right. What Jenny, Ms. Mavorkas is showing me is you don't have the Brickman-Bates stamp. That's how we got it. So we then went and got a certified copy. And so what you would be looking at is page 47 of the report.
Okay, but I was asking the question of why it could come in 803C. I don't see an 803C.
And more particularly, if I could.
Excuse me, I don't see an 803C, unless I'm missing it. I see 803 1 through 24.
If we can, if you look at page 72, Your Honor.
I'm asking the first question. I don't see an 803C. I may not be looking at the right thing.
Yeah, that's right. If you're looking at the rule.
Yes, sir, I am.
Okay. If you're looking at the rule, it's 8038C. I've got a lot of help, and obviously I need it. Yeah. So we got 8038A2. Thank you, Dick. And 8038A3. If you look at those, I would make it very much.
You see, you made me dangerous. You made me start looking at these numbers, and there's not an 80C3. There's 808. Yeah, it's 808C. Okay. Okay. Now that I have the right number, I'm going to overrule the objection. Thank you.
Your Honor,
Thank you very much.
Your Honor, my objection was not hearsay. I mean, he's given you a hearsay exception, but I want the court to note that this is a report from a receiver appointed by the court. His opinion, it uses the word opinion multiple times in the document, and it was done 2 years after the events in question in this case. Has no relevance to this case. It's an opinion of somebody, Seth Kretzler, out of Houston, who, if he had some opinion that the court found relevant, then he should come here and be cross-examined. We can't cross-examine a report from somebody who's not in court. So, Your Honor, there's 3 or 4 different reasons why something like this should not be admitted. First of which is that it's years after the events in question. 2, it's written by a lawyer who's been appointed to be receiver, and it's filled with his opinions about this and opinions about that, which I guess would be some sort of expert type opinion, although we haven't qualified him as such. There's a lot of reasons why this is improper. And the last one, what I think maybe the one you might find most important, they put this on their exhibit list yesterday, and I just got a copy of it right now. So how am I supposed to, 100 pages of opinion by a receiver out of Houston, do anything with this? This is completely improper for various reasons.
Your Honor, that's always true of any publicly admitted document that comes in without a speaker. That right now, that doesn't have a prepared across. He's free to subpoena any of these witnesses. This talks about the very 3 people that we were talking about and the arrangement that they have.
They put it on the list yesterday.
I try to.
Okay, gentlemen, stop. I'm going to relook at this. I based my ruling on your exception.
Thank you, Your Honor.
But he has brought up several other points.
Thank you. Now, if I can.
No, I said wait. You can stop the clock for a moment.
Thank you very much. Your Honor, may I, just information, I was just informed, this exhibit, without being certified, was on our original witness list. Exhibit list. They have had this exhibit notice for about a month and a half.
And we're continuing to hear testimony from Blake Brickman this afternoon. Blake Brickman worked as a deputy attorney general for Ken Paxton. He is a former chief of staff for the Kentucky governor. That was his last job before moving here to Austin to work for Ken Paxton. Actually, I do want to tell you, I shared this on X, formerly known as Twitter.
It's Twitter, Tony.
Just a few moments ago, but I was able to confirm that yes, Laura Olson, Ken Paxton's mistress, was being called to the stand. She was present. We have seen images and photographs and pictures and videos of her in the Capitol today, but Dan Patrick said that she was deemed unavailable to testify. So why? Well, we have been able to confirm that she apparently
Pardon me, Your Honor.
planned to
This may
plead the
not
Fifth
address what you're
and
talking about.
offer
Just
no
wanted to be clear
meaningful
in the record.
testimony,
Our
and that
original
is the reason
notice
both
to them
parties
of this
agreed
exhibit
that she
was
could be
Exhibit
dismissed.
129 in the middle of August.
And certainly,
Did you change the number on the
something
exhibit?
that we
We got
didn't,
change-
frankly,
Didn't see that
we
coming.
did
Yeah.
the new
because
one was
she
certified.
said,
That one
or she
wasn't
was called
certified,
to the
but it was this
stand
document.
this morning,
We-
the
we
first
listed this
prosecution,
exhibit.
the first witness for the
That's what they had
prosecution,
since mid-August,
and
all we did
was
was
present and
introduce
walked
before
into
you
the doors
a
leading up to the
certified
Senate
copy of
chamber
the
and was
exhibit
stopped just short of going in, kind of based off of this 24-hour rule that the
Right.
parties agreed
to
to state that they needed 24 hours
So
notice so they
she-
could prepare.
So she did not dodge, to her credit, she did
She
not
did not.
dodge her
She did
subpoena. She accepted her subpoena. She did plan to come. One other person in this, Ashley, that we don't exactly know the answer to this here, and that is that similar phrasing was used earlier today with Kevin Wood, that he did not plan to testify or would not be testifying. Kevin Wood is the contractor who was working on behalf of the Paxtons. And so that's the second time today that we have heard, excuse me, something similar about a witness. But it is my information that I was able to acquire
On
a short
further
time
review
ago that
with
she
my legal
planned
team,
to plead the
It
Fifth.
appears, looking at the document, it contains double hearsay, so I'm reversing my ruling and sustain the objection. Continue.
Finally, Your Honor, we moved to introduce the grand jury subpoenas as Exhibit 172. This is very bulky. These were the subpoenas, the grand jury subpoenas that have been mentioned throughout the case. I'll tender to Mr. Busby, and because of that we just have one copy for you.
Did you resume the clock? Did you?
Your Honor, these are, just for the record, these have been offered ultimate exhibits, 172 through 185, then 187 through 209, and 218 and 220.
No objection.
You may continue. Let me
Your Honor,
admit these.
may I have
Forgive
just
me.
a moment to see if that's it for us?
Admit 172, 173, 174, 175, 176, 177, 178, 179, 180, 181, 82, 83, 183, I'm sorry, 184, 185, 187, 188, 189, 190, 191, 192, 193, 194, 195, 196, 197, 198, 199, 200, 201, 202, 203, 204, 205, 206, 207, 208, 209, 218, 220, and 2 evidence.
Thank you very much. One
sir.
final question. Would it be possible for us to find out what sections the court considers double hearsay? In case in that report later, we could come back with bracketed, not to argue with you about the ruling of double hearsay, but to maybe admit stuff that was not.
With all due respect, we really did spend a lot of time on that, stop the clock, and on the advice of 4 very wise people up here to help me with that issue, I'm going to stay with my ruling.
I appreciate it, Your Honor. If I have just a second,
Yes.
if I could stop the clock to confer, because I think we may be through, I just want to make sure.
Sure.
Again, we've been listening to testimony from Blake Brickman. I think it's a big question now, Ashley, whether or not he is the final witness
Your Honor,
for
at this time, the House of Managers
prosecution.
rest.
There you have it. The House
Yeah.
rested. It just rested its case.
What did it?
He just rested without a cross-exam. I can recall the witness, though. I'm fine with that. We'll recall this man. We will accept the rest.
Yeah.
And that's how it works.
He's certainly right. I mean, I want to concede he's absolutely right, and I apologize. I think he is entitled to his stay in court. Thank you.
So he has given you your cross-examination, if I'm understanding, Mr. Harden?
Certainly.
Your Honor, we have some motion practice we'd like to take up with the court today.
All right.
Now, is he waiving cross, or?
That I would recall this witness in our case in chief. If there is a case in chief needed from us, I'd like to do some motion practice today.
Well, here's the problem. I messed up and shouldn't have rested until he finished his cross.
And yet you did.
Excuse me. Having this witness come back doesn't make sense. It would seem to me the appropriate thing for him to do is to cross this witness, and then if we had an opportunity or took one to redirect, but it usually should be when both of us have finished with this witness and then we press. The court is having to put up with a screw-up by me. I apologize, but I would really respectfully like for him to go and do his cross.
I don't have to do a cross. He rested. I will recall this witness.
Mr. Harden?
Wait, he is waiving his cross for this stage. I understand. If that's the case, there's no problem.
You rested, sir.
Yes.
And I accept that.
Yes, you rested.
That's fine. And if he wants to put on his case now or he wants to argue a motion, what's the court's preference?
Well, it's now up to him. You've rested. It's up to him to either recall the witness or to make a motion, or it's now his call.
All right. May I ask what about this witness? He's caught in the box.
Is he asking for what?
He's asking about this witness. Can he step down at this point?
Subject to recall. Yes, sir.
Okay, you can step down, subject to recall.
Your Honor, we've seen, Your Honor, the House is...
Let's wait till the witness is out of the courtroom. Mr. Busby.
Yes, Your Honor. As I understand from my colleagues, a motion for directed verdict must be filed and in writing. We have done that. We filed a motion for directed verdict on each of the articles, and I think we've also grouped some of the articles. I think those are dispositive. I would ask that the court consider those. I understand that the Senate would have to vote on those, and I just wanted to inform the court that those motions have in fact been filed, and I don't think you probably are interested in a bunch of oral arguments, so I'll stop it there.
So pursuant to the rules adopted 25-3 by the senators, a motion for a directed verdict as a dispositive motion must be submitted to the members of the court for a vote, as you stated. A motion for a directed verdict is a challenge to the sufficiency of the evidence. Therefore, these motions will go to the senators under the rules. It takes a majority of members present, that is 16 voting members who are eligible to serve as jurors, to grant a motion. If a motion fails to get a majority vote, the motion will be denied.
And I'll sit down and hear.
Do we have the motions? They need to be presented to the court.
Excuse me, Your Honor, it has to be submitted in writing, does it not?
Pardon?
It was submitted in writing. I think you
Yeah,
have it
in
as
writing.
well.
We have to receive it in writing.
Your Honor, we have a cross motion that we will be filing that is being filed as we speak. We'd like to take that up at the bench if we could.
So when would you like to take that up?
Now would be fine if we could take it up, please.
So
We need to get the court a paper copy, but
Yes.
but we have in fact filed it electronically with the court.
I need a paper copy, as we did earlier with the other motion that was filed.
Very well. We'll get on that right now.
Sounds like you have multiple ones. Thank you.
Okay, so just to be clear here, the defense has presented a motion before the court. Motions have to be laid out before the court, but to argue that there is not sufficient evidence to prove essentially the House's case. And so significant because this will require a vote of the body. This motion will require a vote of the body, and it just takes a simple majority, so 16 senators, to say that this case was not proven, that there was not evidence to prove the House's impeachment claims against Attorney General Paxton.
And this could be a very striking, it is a very striking moment in this case. Ashley, I think it's an open question now. What will happen, whether or not this will now come before a vote. As you mentioned, if it is brought to a vote, that would mean that this whole thing could end in short order.
And certainly significant also is that the House noting that they have a cross motion. They too have a motion that they want to file in response, and that they were filing it right then as it was being said. But they were filing a motion for a directed verdict, which means that a straight majority can dismiss the charges.
Again, 16 votes would be all that is needed. So essentially, Ashley, it would require, let's think this through, if we assume all 12 Democrats vote against it, it would require 16 of 18 voting Republicans. Am I saying this correctly?
No, so we need a simple majority. So we need 16 out of 30 to vote. So if all 12 Democrats vote against it,
16 Republicans would have to vote for it.
Oh yes, here's where I thought you were going to go with that. Is that how many Republicans needed to side with the Democrats in order to?
No, that's not. Okay. I was trying to establish what it would take, the threshold
of the 18 Republicans.
Correct.
In the Senate would have to vote.
And
as we can assume the Democrats want to let this play out. So basically, what this would mean is that the trial ends.
The trial would end.
The trial ends. There's no rebuttal. There's no defense bringing forth witnesses. There's no rebuttal evidence. There's no closing arguments, but that this could end.
And just to reestablish, in case you don't know this at this point, there are 19 Republican Texas senators. Angela Paxton is one of them. As we know, she is required to attend. She has been attending, but she would not be able to vote on this particular measure.
Yes, under the rules, she is ineligible to
vote, period. I said this particular
yeah.
measure, but any measure.
She cannot take part in the deliberations, and she cannot vote. And so you're seeing, well, you can't see this from this particular shot. Here we go. Photographer is moving over, and you can see the huddle of senators. These are both Republican and Democratic senators, including Brian Birdwell, who is the chair of the rules. And you also see Senator Royce West talking, who is certainly, he's an attorney who is playing a key part of this in the fuchsia blazer. You see State Senator Joan Huffman, a former judge.
Donna Campbell, who is also a state senator whose district includes a sliver of Travis County, as well as a large swath of Hayes County, Comal County. Again, this is a major moment in this case. I also see Charles Schwartner, Senator Charles Schwartner, who is a doctor, not a lawyer.
Yeah, nearly all of them are kind of gathered.
John Whitmire is there.
Gathered around at this point as they're talking about this, because again, these are the rules that they passed. These are the rules that they voted for. And so this is incredibly significant.
I also just want to take the temperature of this whole thing, Ashley, and what I mean by that is after these days of testimony, Tuesday, Wednesday, Thursday, Friday last week, Monday, Tuesday, Wednesday this week, 7 days of testimony, Tony Busby and company essentially are saying the House did not get the job done, that is no evidence, that there is insufficient evidence to go forward with this case.
And so this vote will tell us, I think, a lot about, it has the potential to tell us a lot about the vote moving forward as to whether
if there is a vote moving forward.
Right, if you even think, but again, this is not the vote on, convict or quit. It's, was there evidence? And so I was Googling, we are not legal minds, Tony Plohetski and myself. And so what a directed verdict actually means. And the definition of a directed verdict, according to the Cornell Law School, is that it is a ruling entered by a trial judge, and we know obviously the rules are different here, but it's a ruling that after determining, a ruling entered by a judge after determining that there is no legally sufficient evidentiary basis for a reasonable jury to reach a different conclusion. So basically, that there's no evidence here. And the rules.
By the way, I just want to tell you, I am trying to get a real lawyer on the phone who can help us. Yeah.
What this is, but even then, that has been the argument, and while that has been the argument of the defense all along, is that there is no evidence. There is no evidence to prove this, and so I think to some degree this may not be taking people who are legal minds by surprise, because they've argued this entire time that there's no evidence, and so now they're just having a motion to argue that there is no evidence within this. The jury not actually deliberating right now, which is why you see Senator Paxton standing there in conversation with a group of other Republican senators about, what is happening presumably right now within this case. And you can see the attorneys at the dais right now talking about what's happening, motioning for Senator Brian Birdwell to come forward. Now, the jurors have not been allowed to approach the dais at all during this, but you see John Whitmire and Brian Birdwell. Again, Brian Birdwell, the senator who is the chair of the committee who came up with the rules. Let's listen.
And for the jurors to meet. Okay. That would be eligible jurors to meet.
Ashley, I've been able to raise James Wood, who spent half of his day with us yesterday, to help us maybe try to understand what is happening. I've just got him on speakerphone. Sage, we're going to try to talk to James for just a couple of moments. James, I'm not sure if you saw this or not, but Tony Busby just filed a motion with the court arguing that there is insufficient evidence for this case to go forward. The state has rested, the prosecution has rested, but I just want to talk to you about the nature of those kinds of motions and how rare they are.
And James, wait, before you answer, I just want to note what you heard, or you might not have heard because we were talking, Patrick say, is that the eligible jurors are now going back to discuss and talk about what is happening right now. And so that's why you see the senators exiting the floor, all of them, with the exception of Angela Paxton, who's not allowed, as they're going to be talking about this motion. James Wood, now let's get with you.
Seems like a big deal to us. Can you advise?
Yeah, I think that I can see where that would seem like a big deal, but it's not unusual at all for defense counsel when the case is about to go to deliberations for a directed verdict. And so this is what seems like a commonplace practice for defense lawyers to do, kind of as a last-ditch effort to get the case thrown out. They usually don't go through, but it's a last-ditch effort that defense lawyers will do.
And what does a directed verdict mean exactly?
It means that you want to put everything aside and say, look, the prosecution didn't put on a good enough case. And so, Judge, there's no issues for the jury to even deliberate. You just need to make a decision that there was not enough evidence here. It's kind of the before deliberation version of what we call a motion for summary judgment, and that's more at the beginning or middle of a case when you try to get the judge also to throw out the case at the beginning. And so these tactics get used at the beginning, middle, and end of cases very frequently, and it's usually by the defense side trying to get off the hook.
So while it may be an unexpected turn for us, it's actually somewhat standard and typical, it sounds like.
Yeah, you'll see this in a lot of trials right before the jury deliberates or when the judge is about to send them. The defense counsel will move for a directed verdict. And like I said, this comes at all stages of cases going into trial. Usually when a lawsuit is first filed, they try it first with a motion to dismiss.
As we saw in this case.
Right. And then in the middle of a case, you have a motion for summary judgment, and that means, hey, there's not enough evidence for this case to go forward, and so you should just throw it out before we waste the court's time and the jury's time bringing them in for this. And this is, towards the end of the last-ditch effort, the motion for directed verdict. After this, we might expect to see, maybe motions for new trials, depending on how the outcome is.
James, let me ask you this. I mean, you say that these types of motions are not atypical. How, in your experience, how frequently are they successful?
I don't think that they're successful very often because, if you think about it, I just went over how there's at the beginning of a case chance, and there's usually in the middle of a case chance for the judge to throw it out. And so by the time you're at the trial, most of your work is done, and most of the issues that are, fundamental on whether the case should be thrown out have already been decided once or twice before. Like you just said, the motion to dismiss early on failed. Well, chances are that this one's going to fail for the same reasons.
That is actually a question that I was going to ask you, James, is that do you think that because, could this be telling? Could this vote on this particular motion be telling about what the senators are thinking right now?
I mean, it very well could be, and you got to think about whether this is an easy political out for them, to not have to render. We talked about this yesterday, why didn't he resign? Well, that's because they still would have had to have this trial. And so maybe now that they're in it, it could be an opportunity for them to politically walk away from it without telling him he's innocent or that he should be removed. And so it's possible that they take a political motivation to do it. But in an ordinary case, once you've heard, the evidence offered, and I think we can all agree that there was a lot of evidence offered, whether people believed it or not is one thing, but there was a lot of evidence for people to make a decision on. And so if it does pass, my prediction is it passes for purely political, easy way out reasons.
And by the way, Sage, I also just want to check to make sure you're hearing James okay. Was on my speed dial, and I've got him on speaker. Got him on speakerphone. You're saying perfect. Thank you. Again, it would take 16 Senate members to vote to grant this motion that has been filed.
James, I want to ask you this. You talked about the amount of evidence that has been presented, and certainly, people would agree with you, but there was absolutely nothing mentioned about Article 9, which alleges that Nate Paul hired Laura Olson, gave her a job here in Austin so that she could move from San Antonio to Austin to be closer to Paxton in exchange for Paxton helping Nate Paul with these investigations. I mean,
there it is on the screen. Yeah.
Obviously, there are 16 articles of impeachment, but we did not hear anything about that article.
Right. Well, it could be that there is no evidence as to that article, and they could do a partial directed verdict and say, well, the president, the judge, Dan Patrick, could come back and say motion is granted as to this article, but not XYZ other articles.
James, I'm asking for just a total prediction here. Is this something that is resolved tonight, or do they sleep on it, or is that anybody's guess at this juncture?
Well, we're going to see how long it takes Dan Patrick to make a ruling. I could kind of give you a preview of that.
Not Dan Patrick, but
the objections.
Not Dan Patrick, but the senators.
The senators would vote
on this because under the rules, anything that would result in the dismissal of any
has
charge
to be taken to the entire
Senate.
Yeah.
Okay, so this is what we call a dispositive motion, meaning that its outcome determines the disposition of the case, if it stays alive or not. So it's going to be I think that maybe look at the amount of time it took for them to review the pretrial motions, and that's probably a similar process to reviewing some of the directed verdict motions.
Gotcha. Ashley, any other questions for James as we work through this?
Yeah, we're working through this, and again, James, I just want you to sort of reiterate what you said, is that this is a typical legal move. We obviously taken aback by this, but this is not something out of the ordinary for attorneys.
Right. This is a typical end of a case defense lawyer move. You see it.
This is really good to know. Thank you, James. Yeah.
Yeah. So no surprise on that one, but it will be a surprise if it's granted in whole.
Do you make anything of Hardin accidentally ending, he mistakenly resting, and then Busby sort of taking it and saying, oh, okay, you know what, Sage, I actually want to go back to this video. We're seeing Angela Paxton walk back onto the floor now alone. She's not allowed to be in the deliberations with the other senators, and she's returned to the floor. Going to have a little beverage there, just a little drink. She's filling up her cup while, she's not able to participate in what they're going to decide here.
So, again, James, one just thing to underscore what you said, it is your belief that if they do grant this motion, you believe that it would be a pure political play and less of something about the evidence itself or the law.
Right, because this is not a decision on the merits of the arguments. This is a decision based upon whether there was evidence provided that speaks to the articles. And so, this isn't a deliberation of whether they believe the evidence. It's just, was there enough evidence given? That's why I think it's going to be hard to say, no, there wasn't. We mentioned the one article that we didn't hear testimony on. That one might make sense because there was no testimony offered. But there's been evidence at least, to give jurors enough to deliberate on and decide the merits.
It's interesting that you're saying this, James, and I know Tony actually has to get ready for
Yeah,
our 6 p.m.
I was going to have a suggestion.
He has to get ready for our 6 p.m. newscast, where he's going to be bringing you a lot of details about this, on TV. But are you telling me to call James? I have his number.
No.
Okay.
Attorney Adam Lowy is also standing by awaiting a call. Yeah, I'm going to write down his number for you.
Chat with him a little bit about what he's making of all of this. One of the things that I think is interesting when you talk about the politics behind this is that this is all happening in a time where just today, former President Donald Trump, who is a candidate running for president, sent an email out to
Donald Trump
Jr., excuse me, sent an email out calling for, this to end and siding with Paxton. And then you have Ken Paxton himself sending a tweet out today saying that he is going to be appearing on Tucker Carlson. He's headed to Maine next week to sit down with Tucker Carlson and discuss the last 2 weeks in Texas politics. It should be interesting, ! So certainly an argument to be made there about the politics behind this.
Yeah, so James, I just want to thank you again for once again providing your expertise to us as we work through this and understand all of the legal issues and legal implications going on. We appreciate your time this evening.
Of course. Thanks, Tony. Thanks, Ashley. Anytime.
Thank you. And we're about 10 minutes away from, less than 10 minutes away from the top of our 6 p.m. newscast. Ashley, with that, I'm going to say I'm going to step away, but
so that you can go. I did the 5, and now you have to do the 6.
Leaving Ashley solo, but not solo, because another local attorney, Adam Lowy, has agreed to speak with us about this whole legal process. Again, not something that we necessarily anticipated happening, but as James Wood was telling us, is not entirely unusual.
And I now have Adam Lowy on the phone. I'm putting him on speakerphone right now. Adam, thank you for taking some time out to talk with us.
Thank you.
Adam, talk to us a little bit. We were explaining, because certainly there are a lot of people tuned into this who are not attorneys and are not familiar with this legal jargon, what exactly a directed verdict is.
So directed verdict means that when the prosecution or the plaintiff rests, the defense says to the judge, there's no case here. The evidence does not support this case moving on. So we want you as the judge, or in this case, the lieutenant governor, to dismiss the case in full. And that's what the defense is going to try to do here.
And now we know that in this particular case, it is not Lieutenant Governor Dan Patrick who gets to make that call, but under the rules of the Senate, it is the senators themselves who get to make that call, and that it is a simple majority vote. So you would need 16 of the 30 senators who are eligible to vote. Well, and I'll say 16 of the 31 because Angela Paxton, though she is not voting, her presence in and of itself, counts towards the total number of votes needed. That a simple majority is what would be needed in order to accept that motion, to grant that motion. But we've spent 7 days, Adam, listening to testimony. So is this possible?
I think it's very much in play. I think if you just look at what happened in the trial, the biggest problem the prosecution had to this point is they have not proven a quid pro quo. They have not shown that Paxton was doing favors for Nate Paul in response for something. Today was a problem for them because we had heard all along about this house, that the quid pro quo was about repairs done to the house or countertops at the house, and I simply don't think that was proven well by the prosecution today. So I think it's truly up in the air with how this thing's going to get decided.
So I want to ask you about that. We did hear a lot about the quid pro quo, and it's the subject of 2 of the articles of impeachment, 9 and 10, that deal with this idea that Nate Paul hired Paxton's mistress, Laura Olson, gave her a job here so that she could be closer to him and move from San Antonio to Austin, and then also the house renovation. But that's just 2 of 16 articles. So is it feasible that they could throw out all the other things that were presented and talked about here over 2 articles?
I think that they have to rule on every article. So if one article gets through, Ken Paxton is removed. But I have always thought the quid pro quo issues were the most problematic for Paxton. The other issues more relate to what the whistleblowers are saying. And I think the whistleblower testimony is very credible, but they are going to argue that there's been no criminal indictment of Ken Paxton and no criminal indictment of Nate Paul on this issue. And therefore, even though the whistleblowers reported them to the FBI, nothing's happened to this point. And that is not grounds to remove Ken Paxton from office.
Certainly interesting to hear your take on this. And we know that there is, while, you know, there's not necessarily supposed to be, they took a juror's oath. We know that there is a political element to all of this. And there is a lot of pressure from conservative Republicans in Texas and frankly throughout the country now, as we're seeing emails being sent from Donald Trump Jr. To supporters to acquit Ken Paxton. Would this let those Republicans, would this motion in particular, without having to vote to convict or acquit, would this let them out of having to make that decision? Is it a safe political move?
I think it is. I think obviously we all know this is a political decision. We know that the 12 Democrats in the Texas Senate most likely will vote to remove him. So you need at least 9 Republicans. But if you think about it, they really need more than 9, because it is unlikely that Dan Patrick wants to have the majority of the chamber being Democrats to remove a Republican attorney general. So either they have a lot more votes or Ken Paxton's going to be cleared.
Interesting. Adam, what do you make of Laura Olson? So when we talk about the quid pro quo, she clearly was someone who would have had the knowledge to speak to that, given that she is the subject of one of the articles. What do you make of them, deciding today that she was unavailable to testify, even though she was here, she was ready to go this morning, that she was unavailable to testify and would be released, and that both sides just sort of agreed to it, and that was that?
I thought that was an absolutely shocking moment of this trial. She showed up this morning, she was ready to testify, and then the defense pointed out they hadn't been given proper notice. So her testimony got pushed back about 7 hours. No one said this is going to be a Fifth Amendment issue. No one was expecting her to show up and not testify. And then all of a sudden, a deal is struck behind the chamber that said that she was going to plead the Fifth, so she was welcome to leave. It is a shocking development. I am totally shocked. The prosecutors did not put her on the stand and make her plead the Fifth. Instead, they let her go. And there's a lot more news that's going to come about what happened there. But it's a huge moment in this trial.
And you think it would have better suited the prosecution for them to actually make her go forward with pleading the Fifth, to put her on the stand and make her do that?
Without a doubt. Somebody always has the right to plead the Fifth. But when you watch a witness on the stand pleading the Fifth, that says something. That says that they do not want to talk about what happened. And when you have a trial like this, when she is a key witness in all of this, I believe the jurors, being the Defenders and the Texans who are watching this, should have seen that happen. It's very different than just hearing that she might have pled the Fifth. So I think that it was a very big mistake by the House prosecutors not to get her on that stand. But we'll have to see what was decided behind closed doors that led to this point.
And I think it's also interesting that that decision happening and what Lieutenant Governor Dan Patrick said would be a hearing that he himself needed to hear and rule on. We did not, typically in a court case, Adam, when there's something that has to happen outside of the presence of the jury, it's still public, right? I mean, those things, I've covered trials. You still are sitting there and listening to what's going to happen, but that wasn't the case here. This was not public.
Correct, and I thought that was a terrible moment. This is the impeachment trial of an attorney general who's a duly elected official. This stuff needs to be public. The public needs to see the decisions that are being made. And to this point, I thought the lieutenant governor did a good job with that. But on this issue, this should not have been decided behind closed doors. We have the right as a public to understand what happened here, and now it's going to be a bunch of rumors and innuendo.
Right. Someone asking, how could she have pled the Fifth if she was not charged with a crime? You want to weigh in on that answer for one of our viewers?
So The right to pleading the fifth is a very powerful right under the U.S. Constitution. You do not need to be charged with a crime. If you feel that you need to plead the fifth for whatever reason, that you are worried about incrementing yourself in any way, shape, or form, you have a constitutional right to plead the fifth. So it doesn't mean that she's going to get prosecuted, but if I was her attorney, if she has been called by the FBI, by the Department of Justice, I likely would have advised her to plead the fifth as well, because that is a much more serious situation than what is happening in the Texas Senate.
Let's talk about how this moves forward. If the senators come out and they vote not to deny this motion, and they essentially say, no, there has been evidence presented, we're not going to throw this out. Defense, move forward with your case. What are the implications of that?
So then that means the defense gets to put on their case. It is quite possible that the defense does not call any witnesses. That's what I've been predicting for a while. But they might. They might call a few witnesses in their defense. We go through that. The prosecution gets to cross-examine those witnesses. And then the defense rests. And it goes to closing arguments. And we go to the penultimate vote as to whether 2/3 of the Texas Senate will vote to remove Ken Paxton on one of these charges.
And what do you see? I mean, we've kind of talked about it, really already about what it means if they do decide to grant this and what that really says. But if that happens, Ken Paxton presumably goes back to being, his suspension is lifted.
That is correct. He will be the Attorney General again. He will not be suspended, and life will go on. And that would be an enormous moment for the state of Texas. We would have an impeached Attorney General who was not found guilty or convicted by the Senate, and he will go on to fill out the rest of his term. We saw that at the national level with former President Donald Trump and former President Bill Clinton impeached in the House several times, but the Senate did not convict. So that is what could very well happen here. I think it is very much in play at this point.
And what do you think that says about, I want to talk politics with you for a moment. What does that then say about those House Republicans who voted to impeach? I mean, the House voted 121 to 23, so overwhelmingly voted to impeach Ken Paxton. They believed the House managers. They believed the documents and the case that the House managers sort of put before them and the documents that they shared with them. Where does this leave them?
I think it's going to be a civil war in the Republican Party. There's going to be a lot of recriminations and consequences. Keep in mind, the Texas House of Representatives never heard any live testimony. They were strictly relying on the investigation by several members of the House in doing their investigation, and it was presented to them in a matter of hours, and then they voted. That was always the critique by the pro-Paxton people of saying, look, we need a full trial, we need live testimony. We have just had that for the past 7 days, and candidly, I think the case has a lot of holes in it. And I think that the Texas Senate could go either way on this, and there's pros and cons to doing either, depending on how you view the situation.
Certainly interesting to see as we are just waiting. Now we're starting to, nope, I take that back. I thought we were starting to see some movement on the floor, but that is just the defense attorneys who are walking out, us really not knowing how long this particular deliberation could last. And this has the potential again to end this trial, this historic impeachment trial. Adam, I don't want to hold you. I don't want to take too much of your time. So, I thank you so much. Is there anything else you might, though, want to add about this entire situation as we're watching it play out?
I think it's a historic trial. I think people have tried to predict how this is going to play out have been wrong. In talking to people at the Capitol, no one really knows what's going to happen. I think that anyone who says they know what's going to happen is just guessing. So I think that we all just need to sit down and see what happens and deal with it from there.
Okay. Adam Lowy, Austin attorney, we thank you so much for taking some time out to talk with us. We appreciate you.
Thank you.
And so, ladies and gentlemen, watching us on KVUE Plus, as we've said, we are in waiting right now. If you are just now joining us, or if you have not been privy to what has happened, the House prosecutors, Rusty Hardin, rested their case. He said out loud that he mistakenly rested their case because he had finished talking to a witness, Blake Berkman, who worked in the AG's office, is one of the whistleblowers, and he announced that he rested his case before Tony Busby and the defense even had a chance to cross-examine him. And so he noted that it was a mistake, but Busby accepted that mistake, that, showing no grace, if you will, to Rusty Hardin on that. He accepted that he rested and reserved the right to recall that witness at a later time if he so choose. But the House rested without using their full 24 hours. But it is certainly worth noting that they would have 24 hours total to not only call their witnesses, but to cross-examine some of the defense's witnesses. So you would think that that is the reason why they would want to hold on to some of their time. But they rested their case, and after they rested, rather than start to present its case, the defense, Tony Busby, filed a motion for a directed verdict. And a directed verdict basically just means that the evidence that was presented by the prosecution was insufficient. It was legally insufficient to prove a case, period. It's not an acquittal. It's not a conviction. It's just saying there wasn't enough evidence here to even remotely try to prove what is alleged. And so that's the motion that they filed. Now, we know that the prosecution filed a cross motion. They did not say what exactly that cross motion was. They were in the process of filing it. It has to be filed not only electronically, but a hard copy has to be given to the court. And so they were in the process of doing that. But that motion we saw during the break before Laura Olson, before it was announced that she was unavailable to testify, we saw pieces of paper being placed on the desks of all of the senators. And so we at this time don't know what exactly that form was, but we do know that that motion was filed by the defense. And so what has to happen, Dan Patrick alone cannot rule on that motion, but rather, because it is a motion that would result in the end of the trial, it has to go to the senators. They are the ones, the eligible senators, they are the ones that have to vote on that, and it would take a simple majority vote. And I say the eligible senators because while Angela Paxton is there, and while her very presence counts towards the total number of votes needed to move any motion forward, she is not eligible to vote. And so a simple majority vote of 16 is what is needed to either grant this motion, or of course the reverse, to deny that motion, to just throw this out. If that happens, that means this trial is over and Ken Paxton resumes his role as the Attorney General of Texas. And so we've been hearing from local attorneys who, while this certainly has caught us off guard, while it certainly has given us a lot of, pause as us watching it as lay people, frankly, in the legal field, or to the legal field, they say this is a normal thing that happens all the time, quite often within, the legal profession, that this is sort of the last ditch effort that is often done by defense attorneys in cases such as this to try to get the case thrown out. So not a surprise really to some of the attorneys who we talked to, Adam Lowy and James Wood, but certainly a surprise to us. No word yet on how long these deliberations are going to happen. The senators are in the back room. We saw Angela Paxton.
Not in the back room.
No, she's not in the back room. She came back out.
By the way, hello, I'm back.
Hello, Tony Plohetski. I was talking long enough for Tony Plohetski to go do the 6 o'clock news and then come back. Angela Paxton, though, pouring herself, her soda in her cup, and then picking up her bag, and then exiting through, the front door of the Senate chamber, not the back door that the senators use, because she can't be with them at the time. So we are actually going to ourselves take a break.
Yeah.
And we will, of course, continue to carry
Monitor the situation. Yes.
Yeah, we're carrying the stream for you on KVUE Plus. This is not going to go anywhere. You just aren't going to hear Tony and I talking for a little while. We're going to see what, if any more we can learn about this, and we will certainly be back once the senators come back to make a decision on this. So please keep with us right here on KVUE Plus.
We're not going home until they go home.
Exactly. We'll be here as long as they're here. So we'll see you back here when something happens in the courtroom. Okay, so we are coming back to you just 2 minutes after we said we were going to take a break because we saw Lieutenant Governor Dan Patrick walk back into, the
chamber
and take a seat at the dais, and the attorneys now up at his at the bench with him to presumably talk about this. So if you have not been privy to what has been going on, the prosecution rested its case and the defense filed a motion for a directed verdict. That means that they want to say there was insufficient evidence presented and they want to throw the entire case out. So this could be...
And apparently the prosecution had a response drafted. They anticipated this. They had a response drafted.
Important thing you said there, Tony. They anticipated this because while this seems, have to be taking the public aback a little bit.
Well, at least two members of the public right here.
No, I mean, we're seeing
absolutely. Absolutely. Yes.
Defense attorneys that we have talked to tell us that this is not unusual. This is sort of the defense's last ditch effort to get the case thrown out, that this happens all the time after prosecution rests, that the defense will try to get it all thrown out.
And in real, quote unquote, real court, attorneys tell us that it is, and civil, that they do this all the time. And it's rare for them to make it across the finish line.
It is. That is the other big point. But we know that this is not a normal court. This is not a criminal court or a civil court.
So if 16 Republican senators decide they want to get together and kill this trial tonight, they could possibly do that.
If 16 of the 18 who are able to vote, and we say there are 19 Republicans in the Texas Senate, but Angela Paxton cannot take part in this vote because she has a conflict of interest, as is stated in the rules. Obviously, this is her husband we're talking about. This could all be over. And certainly, the attorneys we talked to say that there could be political motivation to end this without having to take that vote to acquit or convict. And so while they say this does not typically happen in criminal and civil court, and in real court, like we like to say, in the court of politics, it could certainly be different.
One thing that I just want to point out that I did not talk to Attorney James Wood about when we were talking, that is interesting to me, is if you are the defense and you believe in your case, wouldn't you want to put on your case at this stage of the game? Or I guess why risk it would also be a point too.
And I think that the heavier point on that, Tony, is it's not their burden to prove.
That's
not
right.
for them to prove. They don't have a case to prove.
Yes,
right?
but 7 days of allegations are out there.
But 7 days of cross-examination.
That's also true.
As well,
yes.
to say that they poked holes in it, and it's not up to us to prove a case. It's up to the prosecution to prove that these things happened. And so, we don't have to sit up here and prove that this didn't happen. We just have to prove reasonable doubt.
So we're seeing there Lieutenant Governor Dan Patrick is now leaving the dais. He was there for a few moments speaking to attorneys. I think it's still unclear at this stage what is happening.
Right. We know that but you can see the defense, and that's Dan Cogdell on the defense laughing and joking.
With a smile,
With Rusty Hardin, who is the prosecution. The prosecution was getting ready to file, and they have to turn over a physical copy of their motion, their cross motion, to the court. You do not see the senators on the floor because they are in the back room deliberating right now about what is going to happen with this particular motion. So again, we don't know how long that could take.
Yeah.
So we are going to...
We've had coffee, and we're going to be here as long as this plays out.
Could certainly, we're probably going to send somebody else on a coffee run so we can get a little bit more, in here to keep us caffeinated, because we don't know how long it's going to take the senators to
Lieutenant,
come out and make their decision.
The Lieutenant Governor seems to be walking back to the dais.
Yes,
to the bench.
And senators are starting to come out. That is Senator Sparks.
Oh, was he saying something? Can't hear him.
That's Senator Sparks putting some pages on his, some paper on his desk right there. So not sure if we're going to see other senators walk out.
He's saying something.
He's saying something, but we want to note that the button is not pushed, so his mic is not hot.
If Scott Guest, photographer Scott Guest, could maybe text us what he... Oh, no, text us what he said.
He can't, as someone who's been on that floor, he cannot hear him either.
Yeah,
That's one of the things that you've constantly heard them talk about, speaking into the mic, because the acoustics, again, the Capitol building built a really long time ago, and they were not building it for the acoustics.
For that purpose.
So you cannot hear, and especially being behind the rail, you can't hear what he's saying. But Senator Sparks walked out to his desk, but then presumably walked back into where the deliberations are happening.
So we're going to leave our stream up. We invite you to keep watching it. We're going to take a quick reset ourselves. And every time we say that, Ashley.
Every time we say that, there's something that happens, i.e. Dan Patrick,
sits
sitting
down
and talks. But again, he could be there. And we're seeing Senator Drew Springer. So we're seeing a senator at the dais. He's not the man talking directly to Dan Patrick, but he's the man on the side with the glasses on the top of his head, speaking to a member of Patrick's legal counsel. Let's see where he goes. I'm seeing senators in their seats, actually, at this point. However, we still want to take a reset. We have some things that we have to work out on our end here. And when we get indication that there is any movement, whether it's the senators coming back or Lieutenant Governor Dan Patrick saying something, we'll bring that to you. But keep in mind, this stream is going to stay up and live, and so you can continue to watch and wait with us. Right here on KVUE Plus. We'll see you back here in just a sec.
Members, after consultation with the jurors and both parties, both motions have been withdrawn, and the defense will now call their first witness.
Mr. President, Mr. President, the Attorney General calls Professor Michael Gerhardt.
Bailiff, bring in Professor Michael Gerhardt.
Mr. President, before we proceed, may we approach?
Yes, you may.
All right, and so what just happened just now, just to recap for you, the defense had submitted a motion for a directed verdict, which would have thrown this entire case out if it had majority vote of the senators. After taking some time to talk it over, the defense withdrew that motion, and so that motion was not voted on. The prosecution had filed a cross motion kind of countering that motion, and they also withdrew their motion. And so now we are at the point where the defense is preparing to present its case. And when we have typically been going until 6:30, 7 o'clock each day, Lieutenant Governor Dan Patrick told the defense to call its first witness. They're calling Professor Michael Gerhardt. This is not a name that is, certainly familiar to us. We're waiting to hear who he is, but you can see prior to them calling him, the prosecution asked to talk about a few issues at the bench, and so they are now standing at the dais, presumably arguing a few motions. So really significant thing that happened within, just the past 10 minutes here, where we had what legal experts tell us. We talked to two Austin attorneys who say motion for a directed verdict is not unusual, that it is absolutely something that is standard within the legal field and the legal world, that it is sort of the last ditch effort by the defense to have the case thrown out. because this is not a criminal or civil trial, but rather a political trial, such a move would have to require a majority vote of the Texas senators who are eligible to be voters in this. So that is 30 of the 31 senators. We know that State Senator Angela Paxton is not eligible to participate in any deliberations or any votes on any motions. And so the senators were actually in the back deliberating how they would vote on this motion, which again was not a motion to convict or acquit or even a motion on the merits of the evidence, but rather whether there was enough evidence presented in this case to prove the prosecution's case. We say that, interestingly, because so much of what we heard from House managers during the impeachment was about a quid pro quo, and that Ken Paxton was helping Nate Paul, and in exchange for that help, Nate Paul renovated his home and hired his mistress so that she could move from San Antonio to Austin. And we heard no testimony on that second article, that second point, which is Article 9, that Laura Olson received a job from Nate Paul so that she could move to Austin, and that was a benefit given to Paxton. Again, the attorney's talking with Paxton now. He continues to push the button, which is why you hear me pause, because we think he's going to come back in and talk and rule on some motion. But also, we don't know how long things are going to go tonight. Typically, they'd been going till 6:30. Last night, they went late to 7 o'clock. And if the defense is planning to call its first witness, after 6:30 p.m., it could certainly be a long night for us watching and for the folks there in the Senate chamber. And so obviously some significant movement, and we do not know the substance of what they are talking about in terms of the motion and the issues that they wanted to bring forward after the defense called its first witness. We just know that they are there now talking about, the arguments for and against whatever they are asking for the decision before the court. But it has already been a monumental day in terms of the witnesses that we heard from and the testimony that we heard. Let's, recap some of that for you now. The day started with the prosecution actually calling Laura Olson to the stand. She is the woman said to have having an affair with Ken Paxton, and she was here. She was there at the Capitol. She walked through the entrance to the Senate, but was stopped just short of going into the Senate chamber when the defense sort of raised the notion that they did not have a full 24 hours notice, that the notice that she was being called to the stand happened at 3:53 p.m. and so she would be ineligible to testify ahead of 3:53 p.m. That 24-hour rule is something that both of the parties agreed to give themselves enough time to prepare to cross-examine any witness that might be called by the other side. And so we were waiting for 3:53 p.m. We went beyond that. The prosecution continued to call other witnesses, and we went beyond that. And then, Dan Patrick said he had to rule on a motion, didn't give much detail about what it was. And when he came back out, he said that Laura Olson is present but unavailable to testify, and that both parties agreed that she was unavailable to testify. We have since learned through our own reporting that it is because she intended to plead the Fifth. And so there was some pushback. Certainly we talked with Adam Lowy, who was an Austin attorney, who pushed back on this idea. Well, she said she was going to plead the Fifth, but we should have still seen her do it. They still should have called her to the stand, because anyone can say they're going to plead the Fifth, and it's a totally different thing to actually get up there on the stand and plead the Fifth. And they think that because the quid pro quo was such a key pivotal point in the House decision to impeach Ken Paxton, that certainly the representatives and, moreover, frankly, the people of Texas deserve to at least see her on the stand testifying about what she knew about that said agreement between Nate Paul and Ken Paxton, if there was an agreement at all. And so that was certainly a pivotal moment. And after that, the prosecution rested its case, sort of mistakenly, and no sort of about it, actually, mistakenly. Rusty Hardin admitted that he mistakenly said the prosecution rests, while Blake Berkman, who is one of the 8 whistleblowers, was still on the stand. The prosecution resting its case before Tony Busby even had a chance to cross-examine him. And so, Tony Busby, not extending any favors or shedding any grace towards Rusty Hardin, said, no, you said you rested. You can't take it back now. I accept that you've rested, and I reserve the right to call Blake Brickman back up to the stand at any point, presumably to cross-examine him about that. Before Brickman, we heard from 2 other witnesses this morning. We started with Ray Chester, who is an attorney who represented the Mitty Foundation. And Chester testified to the fact that it was his belief and his feeling that when the Attorney General's office of the state of Texas intervened in the lawsuit between Nate Paul and the Mitty Foundation, it was to the benefit of Nate Paul, and that put pressure on the Mitty Foundation to sort of reach a settlement and try to agree to a settlement, and that it was not to the benefit. That speaks directly to Article 1 of the impeachment articles that Ken Paxton is accused of, and it is certainly significant because until now we've not heard about the benefit to Nate Paul, and that really is, the hinge on a lot of these articles, that all of these actions Ken Paxton was taking and having his staff take were for the benefit of Nate Paul. After his testimony, we heard from Drew Wicker, who was Paxton's executive aide. This is his body man. This is a person who testified he was with Ken Paxton more than anyone else, even his own wife, that he was constantly by his side, taking trips with him, helping him carry out all of the things that he did. And it is this man, Drew Wicker, who heard Ken Paxton talking with a contractor in his home about a renovation, asking for upgrades, and that contractor on 3 occasions in one conversation saying, quote, "I'll have to check with Nate," end quote. Nate, to Wicker's testimony, believing to be Nate Paul, that before those things could be approved, that Nate would have the say in it. And he also testified about the cost of the renovation costing $20,000. That is certainly significant given the evidence that we heard and that was presented by Drew Wicker, that there was water damage to the master bedroom of the Paxton home due to a spring storm that happened here in Austin, and the insurance claim was certainly, and we know that the insurance claim was for that because Drew Wicker actually met with the insurance adjuster on Paxton's behalf. As Paxton was carrying out his other duties, he would have Drew Wicker at the home and with the insurance agents and with the contractors and the workers. And so he testified that, that was the case. It was the master bedroom, but the kitchen was also, going to undergo renovation.
Since we're having an elongated discussion up here,
let's listen in real quick to Patrick.
We're going to adjourn for the day at 9 o'clock tomorrow morning, okay? See you at 9 o'clock tomorrow morning. Okay.
Today, the defense will get the opportunity to call its first witness tomorrow. They are adjourning until 9 a.m. tomorrow morning. The senators are released until then as the parties continue to have, a spirited conversation at Dan Patrick's desk about some legal matters, presumably what will be allowed to be heard in this case. To finish my thought about Drew Wicker, we also heard him testifying and talking about what was happening with the payment for the renovation to the home, that the insurance adjuster had approved a payment of $121,617, and that is the exact amount that was sent to a contractor that had ties to Nate Paul, but the timing of that payment is what has caused a lot of pause, that the Paxtons moved back into that house around the end of June, early July, but that payment did not happen until September 30th. September 30th is notable because that's the same day that the whistleblowers went to the FBI to report Ken Paxton, and they told him then on the 1st that they had made that decision to report him. That payment that Paxton sent a text message to his blind trust to tell them to make the wire transfer for that payment on the 30th, that it went through on the 1st, but the invoice that was sent to Paxton for the amount that was due, metadata showing it was not prepared until October 1st in the evening after those whistleblowers had that conversation with Paxton. So really some question there, and some things that we certainly anticipate we'll hear more about either in the rebuttal evidence or in the closing arguments. But as for now, the trial has ended until 9 a.m. tomorrow morning. So we will be back here with you at 9 a.m. tomorrow on KVUE Plus to continue our coverage of the impeachment trial of suspended Texas Attorney General Ken Paxton. We thank you for joining us for this special KVUE Plus coverage. We'll see you right back here tomorrow morning at 9.